Good morning and welcome to the July 25th, 2022 Land Use Hearing Meeting. I'm Pamela Jo Hatley. I'll be serving as your Land Use Hearing Officer today. Before we get started, please stand if you're able for the Pledge of Allegiance. All right, thank you. Again, I'm Pamela Jo Hatley, and I'll be serving as the Land Use Hearing Officer today. If you have noise-making devices, telephones or computers or anything, please silence those at this time. Thank you. I would like to introduce Tom Hisney now with the Hillsborough County Development Services Department. Mr. Hisney will introduce staff and any agenda changes.
Good morning, Madam Hearing Master. To my left is Carmen Mason with Development Services staff. Throughout the course of the meeting, we'll be joined virtually by various members of Development Services staff who will be rendering findings or recommendations on the various cases, and they'll be introduced as those cases come up. We're also will be joined virtually by County Attorney staff, Cameron Clark and Mary Dorman. Yes, before I read the published withdrawals and continuances, we have one change to the agenda. This is on agenda page 7, item H7, variance application 22-0955. The applicant is Timothy Healy. This application is being continued by staff to the August 22nd, 2022 Land Use Hearing Officer meeting.
All right, thank you, Mr. Hisney. Now I will read into the records the meeting procedures for the day.
Should I read the rest of the published withdrawals and continue?
Yes, before we proceed to meeting procedures, Mr. Hisney will also announce the published withdrawals and continuances.
Okay. And so with regards to the change that I read into the agenda, if anyone is here virtually for variance 22-0955, it will not be heard today. The case will be heard on August 22nd. As far as published withdrawals and continuances, they are as follows. Item A1, special use application 22-0368. The applicant was Tampa Electric Company. This application has been withdrawn by the petitioner. Item A2, variance application 22-0715. The applicant is SL6 Hangar Court LP. This application is out of order to be heard and is being continued to the August 22nd, 2022 Land Use Hearing Officer meeting. Item A3, variance application 22-0722. The applicant is Larry Albritton. This application is out of order to be heard and is being continued to the August 22nd, 2022 Land Use Hearing Officer meeting. Item A4, special use application 22-0836. The applicant is Vobre Altador. This application is out of order to be heard and is being continued to the August 22nd, 2022 Land Use Hearing Officer meeting. Item A5, variance application 22-0849. The applicant is Kendrick and Lisa Callwood. This application is out of order to be heard and is being continued to the August 22nd, 2022 Land Use Hearing Officer meeting. Item A6, variance application 22-0851. The applicant is the Brickemeyer Law Group. This application has been continued by staff to the September 26, 2022 Land Use Hearing Officer meeting. Item A7, variance application 22-0930. The applicant is Drs. Karan and Pallavi Patel, 2017 Foundation. This application has been withdrawn by the petitioner. Item A8, special use application 22-1010. The applicant is Agincourt Industries LLC. This application has been withdrawn by the petitioner. And finally, item A9, variance application 22-1012. The applicant is Sentosa Riverview Owner LLC. The applicant has requested a continuance to the October 24th, 2022 Land Use Hearing Officer meeting.
Thank you, Mr. Hisney. All right, meeting procedures today. First of all, the agenda consists of items that require a public hearing by a hearing master. I will conduct a hearing on each item today and will submit a decision within 15 working days after the conclusion of today's public hearings. My decision will be filed with the clerk of the Board of County Commissioners. The hearings today will be informal. I will ask questions related to the scope of direct testimony and may call and question witnesses as I deem appropriate. I will decide all questions of procedure. I will take evidence, but will exclude evidence that is irrelevant, immaterial, or unduly repetitious. Evidence may be presented in written form, and all testimony today shall be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding of fact unless it would be admissible over objections in a civil court action. The order of presentation today shall be as follows. First of all, for variances, Mr. Hisney will call the case. Then County Development Services will have 5 minutes to present its report and findings. The applicant and the applicant's witnesses will have 15 minutes to present the proposal. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against the proposal. County staff will have 5 minutes to present any amended findings or comments, and the applicant will have 5 minutes for rebuttal and summation. For special use cases, Mr. Hisney will call the case. The applicant and the applicant's witnesses will have 15 minutes to present the proposal. County Development Services will have 5 minutes to present its report and findings. Planning Commission will have 5 minutes to present its finding of compliance or non-compliance with the comprehensive plan. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against the proposal. County staff will have 5 minutes to present any amended findings or comments, and then the applicant will have 5 minutes for rebuttal and summation. The 15 minutes that are allotted for proponents and opponents is the total time allotted among the speakers. So if there are a number of persons who wish to speak, the 15 minutes will be distributed among you. If you have a particular spokesperson you would like to designate to speak for you and represent your views, you may do so. When you come to the microphone today, please first state your name and address. The meeting is being recorded, so please speak into the microphone so your testimony can be recorded. When you're finished speaking, please see the clerk right here to my right to sign in for the record. Now we'll hear from the county attorney's office with the legal requirements and procedures for appeals.
This is Mary Dorman from the county attorney's office. This land use hearing officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed the case, the record of that case is also closed and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decision of the hearing officer and the record made at this public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral argument by the party appealing the decision, county staff, and any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the hearing officer or to intervene in an appeal. 1, the applicant, or 2, anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It is the role of the county attorney's office to ensure that no new evidence or testimony is allowed before the appeals board that was not presented to the hearing officer at today's hearing. The county attorney will recommend that the appeals board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the appeals board that is outside the record created at today's hearing could jeopardize the legality of the appeals board decision, and the presenter of that evidence could hurt their own cause. The safest course of action, then, is for you to write down any comments you make today and repeat them to the appeals board.
Thank you, Ms. Dorman. All right. As I said, all testimony today must be made under oath. So if you plan to speak, please raise your right hand, stand if you're able, and raise your right hand to be sworn in. And all those who are online who wish to speak today, please also raise your hand to be sworn in. Thank you. Do you swear or affirm the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I
Thank you. All right, Mr. Hisney, would you please announce the first case?
So on today's agenda, we have no vested rights cases and no fee waiver requests, no remands and no reconsiderations. So that takes us to section F of the agenda, site development variance requests. And we have one case. It's item F1, application 22-0716. The applicant is David Wright of TSP Companies Incorporated, requesting a variance to encroach into the 30-foot wetland conservation setback area. Also variances to lot development standards. Staff findings will be presented by Ryan Joyce.
Hi, good morning. The applicant is requesting multiple variances to accommodate existing and proposed conditions on single-family home on property zoned PD 85-0139. The variants are existing air conditioning unit. For LDC section 6.01.03.I.3, mechanical equipment such as air conditioning units, pumps, heating equipment, propane tanks, electrical generators, and similar installations may not project into the required front yard, but may project 5 feet into the required rear yard and 3 feet or no more than 50% of the required side yards, whichever is more restrictive. Per condition 2 of PD 85-0139, as last modified by PRS 21-1041, the required minimum side yard setback for single-family lots is 5 feet. Therefore, the required side setback for the air conditioning units is 2.5 feet. The applicant requests a 1.5-foot reduction to the required side setback to allow for a 1-foot setback from the air conditioner to have 1-foot side setback from the east property line. Existing pool enclosure. Per condition 2 of PD 85-0139, as last modified by PRS 21-1041, a minimum setback of 5 feet is required for pool enclosures on single-family lots. The applicant requests a 1.9-foot reduction to the required setback to allow for a setback of 3.1 feet from the rear property line. The patio. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the submitted site plan on June 1st, 2022, is to allow for the construction of a concrete paver patio and screen enclosure within the 30-foot wetland conservation area setback. Per LDC section 4.01.07.B.4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within the required 30-foot wetland conservation area setback. The applicant requests approval for an existing concrete paver patio and construction of a screen enclosure within the 30-foot wetland conservation area setback. The applicant requests a 6.3-foot encroachment into the setback to allow for a remaining setback of 23.7 feet. The findings, a wetland setback compensation planting plan has been provided on the site plan dated June 1st, 2022 that provides equivalent square footage of compensation planting to the amount of encroachment. However, this encroachment is under the threshold of 500 square feet and is therefore exempt from the requirement for compensation plantings. Permits were issued for the pool in October of 2012, NPO 26201, and for the pool enclosure in November 2012, EAL 16369. That is all for staff findings.
Thank you, Mr. Joyce. All right, we'll hear from the applicant.
Morning, Madam Hearing Officer. My name is David Wright. I'm the president of TSP Companies. Our address is 18431 Cypress Bay Parkway, Land O'Lakes, Florida 34638, and I have been sworn in. Today, I'm presenting a request for 3 corrective variances for the property with address 12207 Adventure Drive in Riverview, Florida, zip code 33579, and property folio number 77452.5630. The requested variances are a variance to reduce the required side yard setback for an existing air conditioner condenser pad from 2.5 feet to 1 foot, a variance to reduce the required rear yard setback for an existing pool from 5 feet to 3.1 feet, and a variance to allow a 6.3-foot encroachment into the 30-foot wetland conservation area setback for an existing patio pool deck. The requested variances are corrective variances that are necessary to accommodate the existing air conditioner condenser pad and the existing patio pool deck and screen enclosure that were all permitted and constructed prior to the current property owner's purchase of the property. The air conditioner condenser pad was constructed by the builder, and the pool and screen enclosure were permitted in October 2012 and November 2012, respectively. Property owner purchased the property in November 2020, and a copy of the deed was included with this application. We submitted a complete application package and provided notice to the adjacent property owners in accordance with the Land Development Code. We were not contacted by any citizens requesting information or expressing concern about this request. I respectfully request your approval of variance for wetland setback 22-0716, and I'm available to answer any questions. Thank you very much.
Thank you, Mr. Wright. Just a couple of questions. Are all of these improvements existing, or are there any proposed new improvements?
There are no proposed new improvements. They were all existing at the time of the property owner's purchase of the house.
Okay. And the paver, I guess, pool deck and screen enclosure, were those included in the pool permits in 2012?
I have not been able to obtain a copy of the pool permit, but the screen enclosure that was permitted in 2012 did cover the entire area of the existing pool deck. So I assume that they were included in the original pool permit.
Okay. All right. Thank you very much. I don't have any more questions. All right. Is there anyone here who wishes to speak in support of this application? I should say here or online. Okay. Don't hear any. Is there anyone here or online who wishes to speak in opposition to this application? All right. Do not hear any. All right. Development Services, anything further?
Nothing further.
Okay. Applicant, anything further?
Nothing further. Thank you.
All right, thank you. This will close the hearing then on variance 22-0716.
Okay, that concludes section F of the agenda. We have no sign variances, so that's going to take us to section H of the agenda, which are the general variance requests. First item is H1, application 22-0761. The applicant is Deidre Hickox, requesting a variance to buffering and screening requirements. Staff findings will be presented by Chris Grangillard.
Good morning. Chris Grellenard, planner with Development Services. I'm here to present application variance 22-0910. The applicant is requesting a height variance for an existing fence on a property zoned ASC 1 that is comprised of 2 parcels under common ownership. Per LDC section 6.07.02.c.2, fences in agricultural districts are regulated in the same manner as fences in residential districts, except under certain circumstances that does not apply in this case. Per LDC section 6.07.02.c.1.a, fences over 4 feet in height shall not be allowed within required front yards, except under certain circumstances that do not apply in this case. The applicant requests a 2-foot increase in the permitted fence height to allow a height of 6 feet for an existing fence located on the east and the south property lines of both parcels, but roadways are unimproved platter right-of-way. Findings per LDC section 6.07.02.a.2, no fence exceeding 2.5 feet shall be constructed within the visibility triangle at roadway intersections as described in section LDC section 6.04.03.f and includes the intersections of streets and driveways. The applicant has been informed that the fence height, design, and location must comply with these visibility requirements.
God damn
The
it.
subject parcel is the subject of a code enforcement case, CE 21008901, which has been placed in the case file for this application. That concludes my staff report for variance 22-0910. I'm glad to answer any questions.
Is that the case you called? Which case did you call? Okay. I'm just trying to confirm which case, Mr. Grandleonard.
I am so sorry, madam. I'm so sorry. I had them mixed up. I'm so sorry.
All right. I believe we're on variance 22-0761. Is that correct?
I apologize profusely, ma'am.
Okay. That's all right. Just do you have that case, Mr. Grandleonard?
Yes, I have the right one. It was in the wrong order.
Okay. Let's hear the staff report then on variance 22-0761.
I apologize so much. Sorry.
Thank you.
The applicant is requesting a buffering and screening variance for an existing public service facility on property zoned CN. Is that the right one?
I believe so.
Yes. Okay. Sorry. Okay. Per LDC section 6.06.06.a, a 20-foot wide buffer with type B screening is required on the north side of the subject property due to the adjacent property zoned RSC 6. Type B screening consists of a solid 6-foot high fence or wall, or a 6-foot high evergreen hedge with 75% opacity at time of planting, together with a row of evergreen shade trees planted on 20-foot centers, subject to the specifications found in the LDC. The buffer variance, the facility received development approval in December. The approved plan showed the required 20-foot wide buffer area along with the north property line. However, the building and air conditioning units were constructed with a small encroachment into the buffer area. Therefore, the applicant requests a 2.5-foot reduction to the required 20-foot buffer width on the north side of the subject parcel to allow a buffer width of 17.5 feet. Screening variance. The facility was constructed with a solid screening fence as required. Additionally, the applicant states that the required tree plantings were met. The applicant wishes to replace the existing vinyl fence with a chain link security fence topped with barbed wire. Therefore, the applicant requests elimination of the property of a limitation of the proportion of the type B screening requirement, which requires a solid fence or wall or specified hedge. No variance is requested to the tree planting requirement. Findings: the proposed chain link fence will be topped with barbed wire and have a total height of 8 feet per LDC section 6.07.02.A.3. Fences in the CN district are subject to the same regulations as fences in residential districts. Per LDC section 6.07.02.C.1.G. Fences surrounding public utility structures shall be exempt from setback requirements and height requirements up to a maximum of 8 feet and may include up to 3 strands of barbed wire, provided the wire is at least 6 feet above average grade. The applicant has advised staff the proposed chain link fence will meet these requirements. That includes my staff report. I'll be glad to answer any questions.
All right, thank you so much. We'll hear from the applicant at this time.
Thank you very much. Good morning. My name is Thomas Baker. I work for Tower Engineering Professionals, and I'm the representative of Unity Fiber for the variance request 22-0761. All of what Chris has provided thus far is accurate. We are requesting a variance to the fence height and the fence build type to a 8-foot chain link fence with barbed wire for protection of the public structure or public utility structure. I will be transitioning official representation over to Mr. Kelly McGriff, who is Vice President of Unity Fiber Legal Counsel. And at this time, Mr. Kelly McGriff.
Thank you.
Thank you.
Good morning, Madam Chairman. My name is Kelly McGriff, and I'm with Unity Fiber. Our address is 805 Executive Center Drive West, number 110, St. Pete, Florida, 33702. The property that we are speaking about today is at 10124 East Columbus Drive here in Tampa. Unity Fiber is a certificated telecommunications public utility. We possess our certificate of public convenience and necessity as issued by the Florida Public Service Commission. We have been so certificated since 2001. We have not had any complaints lodged against us in that time. We build high-speed fiber optic internet infrastructure all over the state of Florida in service of the federal, state, county, and local governments, as well as schools, hospitals, and businesses. This project is built in support of the United States Air Force's Gulf Range project and is designed to move a massive amount of information from Eglin Air Force Base down the middle of the state to MacDill. This facility and others were built last year in support of other communications facilities. And we're very appreciative of the work that the county staff worked with us last year to make sure that we could get these facilities built in a timely manner and deliver them to the Air Force in a timely manner. The issues here today are twofold. Number one, this facility has a fence around it, which is meets all the requirements of the code at this time. It's a very short fence on 3 sides and a taller 6-foot fence on the back of the property. It's a solid fence. It doesn't do anything to protect our facility, nor does it do anything to protect the surrounding neighborhood. We've heard from some of our neighbors in that area. In fact, one neighbor is in support of our request for a change in the fence because she's afraid that her children, that'll be a challenge for them to jump the fence because it's a waist-high fence on 3 sides. So we have these facilities in other parts of Tampa. It's a chain link fence topped with barbed wire, and we would ask that the variance be granted to allow that change. as to this. Number one. Shall I continue?
Yes, please.
Yes, ma'am. Okay, all right. Number two, in constructing the facility and planning the facility, of course, we used Mr. Baker and his firm here in Hillsborough County to manage that project. We met with the county on multiple occasions last fall, particularly went through the entire inspection process, had folks out there. We passed every inspection, all of our documents as they were incorrect. We changed them and sent them back and just had a great working relationship with the county. But now it appears in a post-construction survey that we are encroaching by 2.5 feet into the buffer zone on the north side. That we assert is a minor encroachment. As I said, this build is in support of the Air Force, and it would cause a significant and undue hardship on us if we were required to move that facility. It is on a concrete pad. It has high-speed fiber optic internet cables going into the facility, and it is running live U.S. military traffic through the facility at this time. So to take that down and move it would cause a significant hardship, and therefore we ask for a variance in that regard as well. That concludes my presentation.
Just looking over the staff report just a second.
Yes, ma'am.
Madam Hearing Officer, allow me to clarify something. The report that's in your paper backup that you were sent is actually not the final version of the report. The final version of the report is what Mr. Grandillard read into the record, and it's also the version of the report that you will find in optics. This one was a previous version of the report. And so I would then direct your attention, and again, it's the one that was signed on July 15th. It's the only report that's in the optics file for this, a paper backup. I apologize for the error. But the report that was read into the record by Mr. Grandillard is the July 15th. And you'll see there that, as described by Mr. Grandillard, the variance is a reduction, a 2.5-foot reduction to the buffer width, a partial variance to the screening requirement. And then you'll see in the correct report that the fence, that the chain link fence with regards to height and having a barbed wire is actually permitted by code. So no variance is needed for the fence. Other than the screening, the fact that it's not a solid fence. So there's a screening variance to allow a chain link instead of a solid fence.
I see.
There's a reduction to the buffer width. But then as far as the chain link fence, a portion of it being 8 feet high, that's actually permitted by code, as is the barbed wire top.
Okay.
As specified, and I apologize for the confusion.
All right. Thank you so much, Mr. Hisney, for clarifying that. And applicant, you talked about an encroachment that goes to the buffer issue.
Yes, ma'am.
Okay. Understand. Okay.
To the north side.
All right. I think that clarifies questions I was going to have. Thank you so much.
Thank you, ma'am. Appreciate your time.
Mr. McGriff, please sign in with the clerk.
Oh, yes.
Thank you. All right. Is there anyone here or online who wishes to speak in support of this application? I don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right. Do not hear anyone. Then Development Services, anything further?
No, ma'am.
Okay.
No, ma'am.
Thank you. And rebuttal or summation, applicant, did you have anything further you wish to add? No. Okay. Thank you so much. That will conclude the hearing on variance 22-0761.
Takes us to our next case, item H2, Variance application 22-0855. The applicant is Michael and Dolores Morris. The request is a variance to lot development standards. Staff findings will be presented by Isis Brown.
Good morning, Isis Brown, reporting on case 22-0855. The applicant is requesting a variance to accommodate a proposed addition to an existing single-family dwelling on a non-conforming lot that is zoned RSC4. Variances, the proposed addition, per LDC section 6.01.01, a minimum rear yard setback of 25 feet is required in the RSC4 district. The applicant requests a 3-foot reduction to the required rear yard to allow a 20-foot rear setback from the westernly lot line. The second variance is a lot size, is to the lot size requirement. Per LDC section 5.09.06, lots served by septic tanks shall have a minimum of 1.5 acre of upland. The applicant requests a 10,629 square foot reduction to the minimum required lot size to allow 11,151 square feet of upland area. Findings: the subject parcel meets the minimum zoning lot size of 10,000 square feet required in the RSC4 zoning district. The subject parcel is part of the Northern Boulevard subdivision recorded in 1976 as a platted lot created prior to July 26, 1989. The lot would have been eligible for certification as a legally non-conforming lot if left unaltered. However, approximately 18,000 square feet of area at the northerly corner of the property, which is highlighted in blue, was left out in 2006 as per the deed, therefore making the lot ineligible for legally non-conforming lot certification. The last finding, if the lot size variance is approved, the applicant must secure certified parcel approval for their parcel prior to the issue of building permits. The certified parcel review must include the adjacent properties, which will be to the northwest parcel, to receive left out portion of the subject parcel. This ends my report. I'm available for any questions.
Thank you, Ms. Brown. Just clarify, please, the amount of area that was removed from the original lot. Was that was 1,800 square feet, I believe. Is that correct?
Correct. Yes, ma'am. The blue area highlighted on this.
All right. Thank you so much. All right, we'll hear from the applicant.
Good morning. My name is William Dobson, and I'm the agent representing the owners of the property. This is variance 22-0855. I did have a couple of photographs. Is that something that I can submit to you?
You can submit them to the clerk here. Do you want to show them?
If possible.
Okay, there's overhead right there to your right.
Thank you.
And there's another microphone there that you'll need to turn on if you speak from there.
Open. That's perfect, actually. So in this photograph, our subject parcel is 0187055044. That's the folio number for that parcel. It's a little bit unclear because of the numbers on the site, but those numbers are right on top of the existing porch, which is original to the house when it was originally constructed. That porch itself is actually 23 feet from the rear property line. And that is the case when the property was purchased by my client in 2011. What we're requesting is that we are allowed to add in the corner, the bottom, it would actually be the southwest corner of the house, an addition which you previously saw the site plan of. And this is the existing porch. This area is where we would be doing the addition to the home. And we actually just need to come a little bit further past the existing porch to be able to get the footings, et cetera, for the walls. And then this is a little bit further over to the right, showing the full width of what the addition would be. But the exhibit that I'd like to share as a matter of context is simply some of the existing setbacks that are adjacent to the site. Just to the south, there's a home here with a large pool patio and cage, which is 17 plus or minus feet from the rear property line. And then this parcel also has a pool patio and enclosure, and it's approximately 14 feet from the rear property line. I realize pool cages have different requirements, but just so that you understand that we're not coming any closer to the property line with any kind of structure than what these structures already do. So back to this, just to reiterate the request and also to clarify, because when the current property owners bought the land, the parcel had already been removed from the property. So they bought it without that additional triangular portion of 1,800 square feet, and also bought it with an already existing septic system. So any of the nonconformities were existing.
Mr. Dobson, do you have any information on how or why that piece of that lot was removed?
Only hearsay from the client. I didn't do any research to find out why the parcels were replatted, but there was apparently a replatting that went on. I understand that that originally was a large parcel that was broken up by a single family member in order to create plots for homes for their family. So it could have been at that time that the lots were divided and made less, not as large, not large enough for the septic systems to be conforming.
In the staff report, I'm not sure if you have that before you, but it has a sort of a highlighted area where the proposed addition will be, which makes it look like it's going to be closer to the south property line, but on the survey, it appears to be even with the existing home. So is that the plan, to make the addition even with the existing home, just extending that over?
That is the case, and I'll show you this exhibit. It's an actual printout from the AutoCAD plan that shows the addition. I think her graphics were just bolder than the actual wall sizes. It's a, can I zoom in? No? Okay.
I can see it all right.
Okay,
It's-
all right.
So that little section just adjacent and connected really with the existing porch, that's just going to be extended to the edge of the house.
Right, it'll be flush with the south elevation of that wall.
Okay.
And it's 13 feet from the current corner back to the back property line, which is slightly by about a foot past the existing porch. But all of that, based on my architectural layout, is just because of the need to create an additional bedroom and closet of a reasonable size.
Okay. All right. And the hardships, well, I guess there are responses to the variance criteria. Did you want to talk about those at all?
I think I can certainly read them. Is that something you'd like me to do?
No, not
part of the
necessarily.
record?
I can read them. So
Okay.
anything you wanted to add or by way of explanation as
I
far as
think
hardship?
Because I've been part of this project from the beginning as the architect, we tried many scenarios in which to add to the existing house that would be economical. Going up wasn't economical, and any other places on the lot actually are not connected to the house, which would allow for more of an addition. Like we could add to the back of the garage, but it's not allowed by code because the garage is actually a separate building. There were various factors in why we picked this location. Plus, if you look at the way that the function of the hallway is and how we're having to alter the interior rooms to create space for the new bedrooms, it was really the best location for the addition. And it's just a request of, actually, she said 20 feet on her presentation, but I believe it shows 22 feet is what we're
Yeah, the
requesting.
report is 22. She just
Right.
misspoke when
Right.
reading the report.
So I just want to make sure that was clear. It is from 25 to 22.
Okay. All right. That's all the questions I have.
Okay.
Thank you.
Thank you.
Please sign in with the clerk. All right. Is there anyone here or online who wishes to speak in support of this application? Please come forward.
Hi, I'm
Hi.
Dolores. I'm the homeowner.
Okay, and you can bring the microphone down a little bit if you would, please, and speak, get close to it and speak into the microphone. We
Sure.
need your name and address.
Dolores Morris at 1110 Sammy Drive, Tampa, Florida, 33613.
Okay.
Yes, and I'm one of the homeowners. And I just wanted to say what I had heard about that might explain the parcel removal when we bought the home. The man on the other side of the fence in the property that now has that part of the parcel introduced himself. The house sold very quickly. We were the only ones that looked at it. We bought it right away. He didn't know it had been back on the market, and he was a little upset. He was polite, but he originally owned both parcels, and it was for his whole family was his goal. It just didn't pan out. So my suspicion is I know that he did all repairs himself. I just think he moved. I think it was an inter-family, just moving one piece to the other property to keep it within the family. Also, it's, I think, worth noting that my whole neighborhood is on septic. We're not an outlier there. And when I say neighborhood, the street, Sammy Drive, is really its own neighborhood. We have block parties and gatherings all the time. So I also wanted to note that we've had the sign up, of course. We also sent an email to everybody, letting them know what the sign was for and asking if anybody had any questions. And not only did we not have any opposition, I had quite a lot of people express their support to me. And finally, one last thing that I don't have the graphic anymore, but there is also, I know the rules are different for outbuildings, but in one of those rear buildings, it's difficult to see because of the tree covering. There's a large outbuilding in a rear property that's maybe 5 feet from the property line. So if we did square off this corner, I just don't think the house would encroach any more than all of these other houses. Basically, we just lose our banana trees.
Okay.
Okay, thank you.
Understood. Thank you. And be sure and sign in with the clerk. Thank you. All right. Is there anyone here or online who wishes to speak in opposition to this application? Do not hear anyone. All right, Development Services, anything further?
Yeah, I'd just like to point out to the applicant or the property owner, as noted in our final finding in the report, that if these variances are approved, unless there's evidence that the reconfiguration of this lot and the adjacent lot was approved by Hillsborough County when it occurred, then they're going to have to go through a process. I believe it's the certified parcel process in order to have that reconfiguration of both lots. So the other property owner will have to join in prior to being able to pull any kind of building permits. So I just want them to be aware of that this is not the final step. Even if the variances are approved, it's not the final step in the process before you can get building permits.
And Ms. Morris, could I have you step up, please? One more thing, and you heard what Mr. Hisney.
I did, yes,
Okay.
thank you.
All right, and so you understand that. Just want to make sure you understand that.
Yes, I do understand. There'll have to
Okay.
be a second hearing about
Yes.
the property lines.
To certify the parcels.
Okay,
Okay.
thank you.
All right, thank you. All right, this will close the hearing then on application variance 22-0855.
All right, our next case is item H3, variance application 22-0890. The applicant is Laura Goldhammer, requesting of variances to scenic roadway and fence requirements. Staff findings will be presented by Israel Monsanto.
Good morning. Israel Monsanto Development Services. The applicant today is requesting a height and a scenic corridor variances for an existing unproposed fence on property zone AS1 agricultural single family. There are two variances being requested. The first one per LDC section 60702C2A, fences in agricultural districts are regulated in the same manner as fences as residential districts, except under certain circumstances that don't apply to this case today. Fences over 4 feet in height are not allowed within required front yards, except under certain circumstances, again, that do not apply to this case. The applicant is requesting the following: a 2.33 foot increase to the permitted fence height to allow a height of 6.33 feet for an existing fence with 7.25 foot high columns, and also a 2 foot increase to the permitted fence height to allow a height of 6 feet for a proposed fence with 7 foot high columns. Per LDC section 60702C1J, fence columns and posts, including decorative caps and panels, may exceed permitted fence height by maximum of 1 foot, provided the columns are not more than 3 feet in width and are spaced at least 6 feet apart. The fence design shown on the plan submitted by the applicant appears to conform with these requirements. The second variance is for the scenic corridor easement along the road. McIntosh Road, adjacent to the property, is a designated scenic corridor due to the property Residential 1 designation in a comprehensive plan. The road is classified as a rural scenic roadway. And per the Land Development Code, section 60603I2A, which requires the provision of a 30-foot wide scenic easement along that road frontage, which shall be left in a natural state. The applicant requests a 14-foot reduction to the required width of the scenic easement to allow a width of 16 feet. In AS1 zoning districts, the required minimum front yard setback is 50 feet. The site has an existing gate with a masonry wall, 6.33 feet high, that is currently encroaching into the required front yard. And the applicant, based on the proposed plans, is proposing to attach a 6-foot high wall to that existing wall gate. There are wetlands present on site. However, no wetland setback variances are being requested by the applicant at this moment. And we are available if you have any questions.
Thank you, Mr. Monsanto. All right, we'll hear from the applicant, please.
Hello, my name is Paul Goldhammer. I'm the husband of my wife, Laura, who owns this property. Thank you for listening to us. In particular, thank you to Mr. Monsanto for his guidance in helping clarify what we needed to do for the board. This property previously was owned by 4 different parties prior to my wife's ownership. We have only recently moved in. Anything that exists on the property concerning this application was not caused by either my wife or myself, but existed for a period of time. Originally, this property was part of a 40-acre parcel, and the third owner subdivided it into a smaller group and a larger group, one 31-acre parcel and another 8.18-acre parcel on which the original house sits. The entire 40 acres on the eastern boundary was enclosed by a wall with 84-inch columns and 76-inch walls. Sometime after the year 2000, a portion of that fell down on 2714 McIntosh Road, our address. The gate and walls by the gate still remain. Installed many years ago on the left-hand side or the eastern side of the southern side of the property on the eastern boundary are the irrigation system, the water tanks, the pumps, both for the irrigation system and the pump for the house well, the electrical board, and the electrical equipment. All of this was previously enclosed by a brick wall. After the collapse of the brick wall, this is all now closely exposed to the road, leaving the opportunity for a malcontent to literally open up the water and flood the street, turn off our electric, turn off our water. We want to ensure that that is enclosed from bypassers on the road. The only reason we seek a fence of a wall on the eastern side of the southern boundary along the South Road of McIntosh Road is to conform to the existing wall, but at a lower height, so that we can move the wall around the corner in front of the water tanks and equipment to prevent anyone driving by from seeing them, under the theory that out of sight is out of mind. It also, as it exists, is an eyesore. May I show you a picture that I submitted with evidence, or if you already have it in evidence and don't need it, I won't show it.
No, please go ahead and demonstrate the picture. And there's another microphone there for you to use. You'll need to turn it on.
All right. This is a picture of the entrance. That is a picture of the entrance of the property, and that is the existing 76-inch wall and 84-inch columns. If you're looking at the picture, we want to extend it to the left. The reason we want to extend it to the left is because it will cover these water tanks, irrigation equipment, the pump, and the electrical board that is on the small pole to the right of the existing foundation. That foundation is where the wall was constructed. We want to install a wall that will be shorter, but just tall enough to cover the tanks, the electrical board, and the irrigation system from passerbys. There is an existing foundation that meanders across the property, and we intend to use most of that for that purpose. But the principle of this entire project is to neaten up this area and make it visually better. The prior owner acquired this property pursuant to a subdivision prior to 2006. After the wall collapsed, he never went about repairing the wall. This project will also involve a black see-through aluminum fence so that it will run southerly on the eastern portion so that it will block off and prevent anyone from entering near the tanks. We seek then to attach that fence to the existing barbed wire fence that exists on the southerly boundary so that access can only be had to these tanks and electrical board and irrigation system by entering through the driveway. The black aluminum fence will never be higher than 6 feet and in parts will be 5 feet high. It'll have 4-inch spacers so that it is easily to see through. On the right side or northern side of the driveway, we are not going to build a tall wall, but rather a 24-inch wall with a 4-foot or 5-foot aluminum fence on that, see-through. The reason we are building the 2-foot high wall is solely as a balance to the large wall on the southerly side. Again, there'll be a fence on top of it that will be see-through. That fence, sometime in the future, not with the brick bottom, but just as a 5-foot aluminum fence, would be extended northerly along the McIntosh Road to the end of the property to possibly bar participants. But again, it would be a very see-through wall. Whether right or wrong, if you travel on McIntosh Road going south from Martin Luther King Highway 574 all the way down to Jordan Avenue, where McIntosh ends, there are only 2 fences of all the fences constructed in that area that are actually 50 feet back from the road. The benefits of this construction: 1, the view will not be impaired. 2, safety. It insulates the water tanks, the electrical board, and the irrigation system from bad actors. Even though I have exchanged the piping in a way that only allows it to be opened with a special tool, quite frankly, a bright 16-year-old with a 1x1 can figure their way around it. The system needs to be secure. In closing, we have only had 2 comments at the property, both of them positive, from neighbors who be happy to have those water tanks blocked from their view. Incidentally, to our west is a 31-acre pasture for cows. To our south is approximately 40 or 50 acres of strawberry farm. To the north, of course, is the lake and then the railroad, and then out to 574 or Martin Luther King. To the right, or rather immediately across the street from McIntosh, there is a development of nice houses of which no one has voiced a complaint. This will enhance the finished view. It'll protect the utilities. It is not a detriment to the neighborhood, but I am asking for a height and placement variance for the fence as well as for the wall. It is important to note that if we complied with the required placement of the fence today, it would be behind the utilities and not afford any protection from the road. Thank you. If you have any questions, I'm happy to answer.
Just a couple of them, please, Mr. Goldhammer. So just to clarify, so from your driveway south to the property boundary. Or
Facing the driveway?
Right, so facing the driveway to the left.
Yes.
So south. You wish to construct a 6-foot-high solid wall, is that correct?
Not exactly. It'll be 6 foot at the first section attaching to the 76-inch wall and the 85-inch or 84-inch column. It'll be shorter. Then the next section will be 6 inches shorter. And the next section will even be 6 inches shorter than that, stepping down from 6 foot to 5.5 foot to 5 feet. With the final decision being made as to the exact number of inches, whether it's 48 inches or 52 inches or 68 inches, well, not 68, 60 inches, based on when you stand on the road, will the equipment be blocked from the driver passing by or the kid on a bicycle or anyone?
But that will be a solid wall and it'll go from the driveway to where the property boundary is.
No,
is that correct?
It'll be a solid wall and it will only go until it passes the utility tanks and electric board. Then it will step down to a 2-foot wall with a fence on top of it all the way to the end of the property. It would still be see-through.
And how tall will that be? Is that to be determined? But
well, it's first going to be a 2-foot wall for about 12 feet with a 4-foot fence on top of it. Then it will drop to a 5-foot fence, no wall to the rest of the end.
Okay, understood. Then on the other side, from your driveway going north or to the right.
Right.
Does that section of it require a variance? Is it going to be?
Yes.
Okay, but it's not going to be a solid wall. It's going to be.
This is a picture of the right side. The gate has since been repaired. You can see the foundation turns and heads towards the road, and there is irrigation equipment there. There, we're going to clean up the side of the wall and make a 2-foot wall, which will go for about 40 or 50 feet. Later, not in the immediate future, we may attach a 4-foot aluminum fence to it, which after the 50 feet would continue to the north end of the property.
Okay, so 2-foot wall with potentially a 4-foot aluminum fence on top of it.
Potentially. This is a picture of the foundation that exists going around towards the road. And this is a picture of where it turns and runs parallel to the road. That area is going to be left open for the time being. It is never going to have any kind of brick wall on it. It is eventually, possibly, going to have a 5-foot black aluminum fence, which would run to the northern boundary and then turn westerly to the lake.
Okay, understood.
I might add that if we complied with the variance, the distance between the lake and the variance compliant fence would make maintenance difficult with large vehicles in that area. And quite frankly, we have vehicles driving up and down our lawn almost every day for maintenance.
Okay,
Any questions?
no further questions for you. Thank you.
Thank you so much for your time. I appreciate it.
Please sign in with the clerk over
Yes,
here.
ma'am.
You can leave any photographs if you wish with the clerk.
Well, these were filed
Okay,
previously.
okay. I'll have them then. Thank you.
Thank you.
All right, is there anyone here or online who wishes to speak in support of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, don't hear anyone. Development Services, anything further?
No, ma'am.
All right, thank you. And applicant, did you have anything further you wish to add?
No, thank you.
All right, no, thank you. That will close then the hearing on variance 22-0890.
Our next case is item H4, variance application 22-0898. The applicant is John Whitehead, requesting a variance to fence requirements. Staff findings will be presented by Sam Ball.
Okay, good morning. Sam Ball, Development Services. The applicant is requesting a height variance to install a new 8-foot wall on residential agricultural zone property located at 18825 Gun Highway. According to section 60702C2, regulations for fences in agricultural districts shall be the same as for fences in residential districts, except under certain circumstances which do not apply to this case. Per LDC section 60702C1, for fences in residential districts, the maximum average height of any fence or wall in this case shall be 6 feet, except under certain circumstances that do not apply. The applicant requests a 2-foot increase to the maximum permitted wall height to allow a height of 8 feet for a proposed masonry wall. Additional findings, this section of Gun Highway that abuts the subject property is designated a rural scenic corridor, which requires a 30-foot wide scenic easement along the roadway that must be left in a natural state. This requirement be met because, according to the site plan submitted by the applicant, the wall will be set back 50 feet from the north property line along Gun Highway. Also, because the wall is not within the 50-foot front yard setback required by the property's AR zoning, it is not subject to the 4-foot high maximum height limit for walls in required front yards. That concludes my report. Thank you.
Thank you, Mr. Ball. All right, we'll hear from the applicant, please.
My name is John Whitehead, 18825 Gun Highway. I thought Mr. Ball explained it exactly the way we had discussed. Him and I had done some extensive work on the parameters of what we could do in relation to Gun Highway and so forth. So if you have any questions, I think he explained it exactly perfectly.
Yes, Mr. Whitehead, just clarify the applicant proposes to put an 8-foot solid masonry wall, and that will go the entire frontage of the property. Is that correct?
Not the exact entire frontage. There will be a gate system and an entry, house, so to speak. This is a large estate. So there is a section there that will be permitted at a different time. So it's not quite the entirety of the front of the parcel, but it definitely takes up a a substantial amount of it.
So along the entire frontage on Gun Highway, except for where the driveway entrance is, where there will be a gate, is that correct?
Correct.
Okay. And could you speak to the hardship criteria, please?
Hardship, I don't know if I can exactly call it a hardship. The hardship is a concern from the client that his property and his proposed estate and what we're building there is done in such a way that it's safe. And I think that it's more of a need and that concern. We never identified an actual hardship per se.
Okay. Can you speak to why an 8-foot masonry wall and not a 6-foot masonry wall?
I think for the aspect of what is being built, I think an 8-foot tall is warranted. An 8-foot tall wall is warranted based on the scale and magnitude of the project. I also think that the difference between an 8-foot and a 6-foot wall, is a perception thing, but it certainly enhances, safety from that standpoint.
All right. Anything further?
Not at this time.
All right, sir, please sign in with the clerk over here. Thank you. All right, is there anyone here or online who wishes to speak in support of this application? All right, I don't hear anyone. Is there anyone here? I'm sorry, someone coming to speak in support. Is that correct? All right, thank you. Please bring the microphone down.
Absolutely. My name is Mary Greco Smith, and I'm here my address is 4801 Valhalla Lane, Plant City, Florida, 33565. I'm confused because in this description, it says that it's 70 foot south of Valhalla Lane and Hawk Griffin Road intersection. That is Plant City. It's nowhere near Gun Highway. So I just want clarification on this.
One moment, please.
Sure, certainly.
County staff, possibly speak to the actual location of the applicant's property, please.
Yes, let me pull up the. Okay, so the location was listed at 70 feet south of Valhalla Lane and Hawk Griffin Road intersection. I'll have to pull that up on my map just to see.
Yeah, the property is located on Gun Highway near Apron Springs Road.
Which is nowhere near Plant City.
Yep. Hold on. We're checking some items here. Okay, so yes, the location on the agenda is incorrect. However, the location that was on the letters, the notice letters that were mailed out was correct. So the case is in order. There's not a notice defect regarding the location on the notices. There's just an error here on the agenda, but the case is in order.
All right. On the variance application, it shows an address of 18825 and 18915 Gun Highway in Odessa. Would that be correct? As county staff? That's closer to it than Plant City, right?
Yeah.
So we're looking, this is involving property on Gun Highway in the Odessa area, correct? And it is not
correct.
Plant City.
No, it's not Plant City.
Okay. Thank you for the clarification.
All right. Thank you, ma'am. Ms. Smith, we need you to sign in with the clerk. Thank you. Okay. All right. So the agenda is incorrect. The application is correct. And the public notice was correct. Okay. Thank you, county staff. All right, is there anyone here or online who wishes to speak in opposition to this application? Please come forward. Make sure you can pull it down so it's close enough to speak. Thank you.
Hi there, my name is Lisa Cheryl Tingen, and I live at 8402 Old Country Road. I also own property at 8505 Old Country Road. And I'm here today with my neighbor who also has voiced opposition via a letter with regards to the variance 220898. So we're opposed to the height of the fence. They're calling it the wall. The wall is for all. One of the main reasons why is it's just not consistent with the character of our neighborhood. Also, it doesn't appear to be consistent with the land development code for Keystone, the rural development standards. Section 3-08-06 with regards to design. Nowhere in there do I see that an 8-foot wall, solid, opaque, would be something that would be good, that would enhance our community. It's also going to be going down the side, the rear of the property to the north of my neighbor, which he's lived there for 50 years and nobody has an 8-foot concrete wall going down the side of the property down to their lake, because we all are on the back of a lake. So the applicant in his application, I did not see that there was a hardship that not having an 8-foot opaque wall would create for a scenic corridor. I believe that area right in front of Gun Highway is a scenic corridor. I could be wrong. I'm speaking just from what I've read. I'm not positive. But I just don't see how in his application he says it's going to enhance the community and that the wall is for all. We don't typically have a lot of that going on. It's not a subdivision. So it's not as if there were all these conditions and everything put out. And then we've learned that the new entrance to this property is going to be from Gun Highway and Tarpon Springs Road. So if you were on Tarpon Springs Road and you were going east, essentially that traffic light is going to be, if you went straight, the new location per the site plan. So where does the wall stop if it's approved? Where does it begin exactly? Because that's not permitted yet. So there just seems to be some unknown variables. I feel like if I could encourage some good communication between the landowner and the other adjacent owners with regards to what this, could do to our community, that would be great. Maybe a different type of fence, maybe one that's more consistent with our neighborhood and not, an 8-foot wall. Therefore, also, we have a lot of wildlife in the area too. So it's important. And I haven't heard anything about buffering for this wall. I know it's not the 30 feet. It's going to actually be at 50 feet, but how is that going to be maintained? There are so many trees that are marked right now to be removed that have been there for, 60, 70 years. I mean, they're going all along Gun Highway. So where does that stop? Are we no longer going to see those trees or have that scenic corridor? What type of landscaping is in place or going to be in place? So just a lot of questions. Not trying to be in opposition. We want this person to have their privacy. We want them to have their safety. But nobody else around there has that. It's not in Avila. It's not in Tampa Palms. It's in rural, beautiful Keystone, Odessa. Thank you.
All right. Thank you, ma'am. Please sign in with the clerk's office. Is there anyone else who wishes to speak in opposition to this application? All right, don't see anyone. Development services, anything further?
Yes, ma'am. So with regards to the question about this fence being located in the Keystone or Odessa Rural Development Standards, the portion of the code that I believe was cited, 30806B, which deals with fences and walls, those special design requirements do not apply to fences and walls that are in agricultural districts or residential districts, except where you have like a residential subdivision and you have a commonly owned wall that's owned by the HOA. But for privately owned walls and fences on residential lots, those standards do not apply, the design standards that were referenced. Also, it was stated or questioned about the scenic corridor. This is noted in our staff report, that there is a rural scenic corridor on this section of Gun Highway, and it requires that the first 30 feet of the property coming back from the road is maintained or left in a natural state. As was noted in the report, this fence wall is actually going to be set back 50 feet. So it's well outside of the scenic easement area. And then finally, as far as removal of trees, those are subject to permitting by Natural Resources staff.
All right, thank you, Mr. Hisney. Applicant, did you have anything further? Any rebuttal? Well, come forward. We need you in the microphone, please.
Just speaking to her point, I can understand. I understand, without seeing the full scope of it, how you could have a concern. I put my information on there. The reality is the tree line and the scenic corridor, obviously, as he mentioned, we're 20 feet beyond what we're required to be. And all of those trees, part of the reason for the wall is to preserve all those trees on there. So they're very tall, so it will definitely be an enhancement. That wasn't just idle words we put on there. But I do understand from someone else's perspective, not being able to understand it, how you may perceive that. But we're leaving all those trees. Everything inside of there is going to be left in full natural state the way it is. And that was our intention the entire time. That's all I have to say on the matter.
All right. Mr. Whitehead, I believe there was a question also raised about whether the wall would go down. I'm not sure if she meant the south property boundary or the north property boundary, but I would like to know exactly where the wall is going to be on the property other than the front. You've already explained that, but will it be on the south or the north property boundaries as well?
Yeah, on the south side, the way the parcel is shaped, it's a little irregular on the south side. It returns towards the east about 150, 200 feet. So there will be a section there. The north side is where the wall is, runs all the way basically from the front to the wetland buffer back there. So that's probably 1,300 feet of wall or so.
Okay. That's all the questions I have, sir. Thank you.
Is that portion, sir?
Mr. Whitehead?
On the side property lines, is that portion of the wall going to be above 6 feet?
Can you repeat that?
On the side property lines that you just described, is that portion of the wall going to be above 6 feet in height?
8.
Okay.
All right. Thank you. So the variance is for to allow an 8-foot wall actually along the frontage and that section of the south side and also along the north side all the way back to where the wetlands start.
Correct.
Okay. All right. Thank you.
Thank you.
That will close the hearing on variance 22-0898.
The next case is item H5, variance application 22-0910. The applicant is Nguyen Tri and Trong Sin. They are requesting a variance to fence requirements. Staff findings will be presented by Chris Grangelar.
Good morning, Chris Grandlar, Development Services. I'm here to present variance 22-0910. The applicant is requesting a height variance for an existing fence on property zoned ASC 1 that is comprised of 2 parcels under common ownership. Variance per LDC section 6.07.02.c.2. Fences in agricultural districts are regulated in the same manner as fences in residential districts. Except under certain circumstances that do not apply in this case. Per LDC section 6.07.02.c.1.a, fences over 4 feet in height shall not be allowed within required front yards except under certain circumstances that do not apply in this case. The applicant requests a 2-foot increase in the permitted fence height to allow a height of 6 feet for an existing fence located on the east and south property lines of both parcels, which abut roadways or unimproved platter right-of-way. Findings per LDC section 6.07.02.8.2. No fence exceeding 2.5 feet shall be constructed within the visibility triangle at roadway intersections as described in LDC section 6.04.03.f and includes the intersections of streets and driveways. The applicant has been informed that the fence height, design, and location must comply with these visibility requirements. The subject parcel is a subject of a code enforcement case, CE 21008901, which has been placed in the case file for this application. That includes my staff report for variance 22-0910. I'd be glad to answer any questions you may have.
Don't have any questions for you. Thank you.
Sure.
All right, we'll hear from the applicant now.
Good morning. My name is Hai Tran. I'm a representative for the owner of Mr. Kubian Nguyen at the 2113 and 2123 South 86th Street, Tampa, Florida 33619. The reason I'm here for today is asking for a variant of keeping the existing fence that was put up there as a 6 foot tall. And reason for that, the owner, I'm from California, they are very old, elderly. The homeless people will live in the front of the property and been drinking and then musicking very loud and threatening him so many nasty words. I don't want to say it here. And if you look along the 86th Street from Causeway all the way to the end, both sides of the road, all the fence are 6 foot. And this is a very heavy traffic with checking access. So I would like for the variant to be granted, please.
Okay. Anything further?
No, nothing further.
Okay. All right, I need your, to sign in with the clerk here, please. Thank you, sir. All right, is there anyone here or online who wishes to speak in support of this application, please? All right, don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? Please come forward. There's a microphone, yeah, right here. Okay. Thank you. Can you pull up to that?
Hi, my name is Michelle Junkel, and I live across the creek from the applicant. And it's not so much that I have an opposition to the fence remaining as he has put it up. It is the fact that it's extended further into encroaching into the county's egress that is on either side of the creek. And there's been a lot of land clearing that was done along that area. And again, as done with the fence, it was done without proper permitting. I don't have an opposition to him feeling secure and safe in his property, because I do understand the homeless camp that has set up across the street in Coca-Cola's property is, well, it's gotten a lot better since they've cleaned them out and chased them away, but they just keep moving around the property on that 168 acres. So I can understand them feeling not safe, and I don't mind the wood fence going up as long as they respect the egress lines and don't continue down into the creek bank that surrounds the property on the north side.
All right, just one moment. I'm trying to pull it up online so I can see better what you're talking about. So you said the existing fence extends further than the property boundary?
Right. They've actually extended the fence on the north side of the well, it's the north side facing 86th Street that goes down towards the bridge.
Okay. And
Because
so-
that's a county egress right there also. And the wood fence is going past that. It's part of the Delaney Creek widening project.
Okay. Can you tell me directions? Is it extending too far north or too far south or east?
It's extending too far north.
Okay.
On 86th Street, on the north side of their driveway.
Okay.
And they've done a lot of land filling right there, and there's been some construction debris that was put in up there to fill the land right there.
Who's doing the
landowner?
This landowner, this
Yes.
applicant?
Yes. I've lived there 54 years. I've known every single one of the owners of that property.
And that's on, is the construction going on this property that is subject to this application?
Well, that's the two parcels. They're mixed together. If you look at the Google Maps, you could see how many trees were there prior to them moving in. And now the land has been almost completely cleared of the large oaks. And those were oaks that buffered along the creek bank to keep it from washing away.
And can you tell me where is the creek in relation to this property?
It is the northern boundary.
The north side. Okay, I see it. All right, thank you. Anything further?
No, and as again, I don't mind the fence staying as it is because you want to feel safe in your home. I don't have a problem with that, just so long as it doesn't continue to keep being added on to, especially on the northern side.
Okay. All right, thank you. Please be sure and sign in with the clerk. Is there anyone else here or online who wishes to speak in opposition to this application? Okay, do not hear anyone. County staff, anything further?
Nothing further, ma'am.
All right, thank you. Applicant? Could you come forward, please?
Yes, ma'am.
All right, could you speak to the potential construction or tree removal going on the property?
With the tree removal, because the owner have planted some of the tropical fruit inside the property, and the construction debris on the outside of the property will be removed.
That part of, there's part of the fence, is that what you said? Part of the fence will be removed?
By the right corner of the property, is that correct, the one that you're talking about?
Okay, I need you to be on the microphone. All right, sir. So is there a portion of the fence that goes off the property?
No, ma'am.
Or that goes further, that extends further than the property line?
No, ma'am.
Okay. Is there construction that's being done that's off the property boundary?
No, that was just the debris was dumped over there by the tree removal.
Okay, so there was debris there from the tree removal?
Yes, we have contacted them many times for them to remove that and to keep, pushing it back.
Okay, and that's on the subject property?
Yes.
Okay.
That was outside property line.
Okay. All right, thank you so much.
Thank you.
All right. All right, that will close the hearing then on variance 22-0910.
Our next case is item H6, variance application 22-0932. The applicant is Christopher Larson. They're requesting a variance to accessory structure requirements. Staff findings will be presented by Tim Lampkin.
Good morning. For this request, the applicant is requesting setback variances for a proposed accessory structure on property zoned RSC 6. Per LDC section 6.11.04.c, accessory structures shall be permitted in front yards at twice the depth of the required front yard, or 50 feet, whichever is less, Per Land Development Code Section 6.01.01, the RSC district requires a minimum front yard setback of 25 feet. Therefore, a minimum front setback of 50 feet is required for the subject accessory structure, which the applicant requests a 30-foot reduction to the required front yard setback to allow a front yard setback of 20 feet from the west property line. The staff notes that the subject property is accessed via Line-Sider Drive, which is on the west side. Therefore, the required front yard is located on the west side of the property. There is also a wetland preservation area located on the south side of the property. Portions of the existing house and pavers encroach into the 50-foot setback from the wetland line. However, the applicant elected not to include a wetland setback variance in this application. If the applicant seeks a wetland setback variance in the future, a new application will be required. And that concludes staff's presentation, unless you have any questions.
All right, thank you. We'll hear from the applicant, please.
Good morning. My name is Tu. My office address is 14031 North Del Mabry Highway, Tampa, Florida 33618. I'm here representing the applicant. The applicant owns a parcel having folio number 075959.0112 located at 8014 Line-Sider Drive, Riverview, Florida 33578. The parcel is in the urban service area and has a current zoning of RSC 6 with a future land use designation of R6. Total land is 1.07 acres. He is proposing accessory structure, detached garage to use as a workshop and for storage for a small boat and vehicle. Per LDC, since the proposed accessory structure is located in the front of the main structure, it is subject to the 50-foot front yard setback. A variance is requested for section 61104C1. The applicant is requesting a front yard setback of 20 feet in lieu of 50 feet, resulting in a difference of 30 feet. The subject property has the following unique and singular hardships not shared by adjacent property owners in the same RSC 6 district. One, the subject property shares a driveway easement with adjacent property owners to the north and west. The property is accessed via Line-Sider Drive from Riverview Drive on the west side. Therefore, the required front yard is located on the west side of the property. Two, the existing single-family home was built in 1953. However, the applicant purchased the property in 1997. The home is situated toward the south side of the property near the river. Therefore, the proposed accessory structure is subject to the front yard setback at twice the depth of the required front yard in the RSC 6 district. Three, due to the subject property's location and elongated shape, the adjacent property owner to the west is subject to a side yard setback of 7.5 feet, while the applicant is imposed to a front yard setback of 50 feet. Thus, we are requesting a 30-foot reduction to the front yard setback to allow for a setback of 20 feet from the west property line. With these unique and singular hardships I have presented, we respectfully request your approval for this petition. Thank you.
All right. And Ms. Mai, just to clarify, the purpose for the setback variance is to allow construction of a garage structure or a...
It's considered a detached garage. He'd like to store his small boat and vehicle and have a workshop there.
Okay. That's all I have for you then. Thank you.
Thank you.
Please sign in with the clerk. All right, is there anyone here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application?
I'm good there. Good morning. My name is William Mirisch. My address is 8012 Linesider Drive. I own the property to the north of Mr. Larson's. My property sideline abuts the front property line of Mr. Larson. I'm in opposition to this variance, and I'm also in opposition to the construction of this structure. I spoke to Mr. Larson about this. I understand the structure is going to be roughly 40 by 80 feet in size. That is, I think, quite a large structure. I understand it's also going to be a metal structure, which aesthetically is probably less pleasing than a building, big or so. Currently, Mr. Larson has 2 sheds within about 10 feet of that property line. Also, there are chicken coops adjacent to the sheds. And these are all, I'd say, approximately within 10 feet of the property line in question. I don't know how rulings impact sheds or chicken coops, but that's a concern of mine as well. This structure now would be roughly 20 feet from my property line, and that would be to the east of the chicken coops and the other 2 sheds. So this is encroaching upon my property line. I have some pictures of my property to show you. Let's see what we have here.
While you're getting those pictures, Mr. Mirisch, you said the structure would encroach on your property line? Do you mean it crosses the boundary?
No, I'm sorry. I misspoke. It's basically, it's impeding the scenic view I have of my area. I'll give you a little background on the area. This is a cul-de-sac off Riverview Drive. There are 6 homes, each of them fairly generous lots. It's quite scenic. I actually paid a premium for my home because I found the property to be unique, very open, very park-like. In fact, it was marketed by my realtor as being a park-like area. And I'm in favor of maintaining that. So I've been doing my best to keep that going on. This is a view of the front of my house. And you'll notice that I have a porch there that wraps around the house. That is technically the front of my house, which faces the river. There from the camera. So that's a view facing south toward Mr. Larson's house. That structure would be pretty much dead center, I think, in that picture once it's constructed. And I do have a view from my porch of my view of the river. And there we go. So the structure would roughly be built, I think, just to the rear where that cart is right now with the tree materials. And obviously that would be pretty much dead center in the middle of my view, my view from my home. So I'm in favor of upholding this 50-foot variance, but I'm also I also feel very strongly that this structure is not in keeping with the character of our estate. My neighbors here, Mark Perez, he feels the same. I understand Mr. Larson needs space, and I respect his right to build on the property. I think there are probably other options open for this structure. I told Mr. Larson I'm in favor of the structure being pushed back on his property toward the east. So maybe that's a consideration. I don't know if that's going to work for him because I think obviously he'd like to have the garage as close to the road as possible. The road that enters, Linesider. So that's, I think that's what I have basically. I'm in opposition of this variance, and I'm in opposition of the structure. I'd like to see if there are other options for the structure.
All right.
So,
okay.
I also have one other question.
Yes, sir.
Is there any ruling regarding structures such as small sheds being in proximity to my property line, or is that does not apply?
The question before me today is the variance.
Correct. So, okay, very good. Thank you.
All right, are you going to submit those photographs into the record? Okay, please leave them with the clerk here and sign in with the clerk.
Thank you.
Thank you, sir. All right, is there anyone else here or online who wishes to speak in opposition to this application?
Hello, my name is Mark Perez. I live at 8011 Linesider Drive. I've been in Florida all my life. I'm fourth generation from Hillsborough County. And I've seen a lot of changes and not all for the good. And I'm here in opposition to the variance that requests changing the front yard setback of 13 feet in lieu of 50 feet, resulting in a difference of 37 feet. I read this on the OPIC, the young lady that represented, we have different numbers, but the request claims that the resident has a hardship because of its elongated shape. I disagree with that. Both riverfront properties to the east at 8015 Hancock and to the west at 8013 Linesider have properties with elongated shapes. Their houses are also situated in the rear near the Alafia River. Their homes also have detached workshops, barns, garage, whatever you want to call it. Both of those homes to the east and the west built their garages complying to the current zoning ordinance. Furthermore, my concerns are that if the zoning board allows this request, it will set a precedent that deviates from the focus on how land is currently being used today and how it will be used in the future. Stated on the Hillsborough County's webpage, the zoning board's goal is to provide for public safety and protect the character of our neighborhoods. And that's why I'm opposing this. I have a drawing, but I don't think it's going to show. We could take a look at it anyway.
All right, you can turn that other microphone on there if you would. There you go.
Well, you think that's a good show? You might be able to see some of it. Okay. On this drawing, okay, right below, okay, you can see my face. All right.
I can see it.
Right here, this is the property where the shed's gonna be built. And from the way I understand it, he wants to put it way up here. And there's other places to put it. Now, this is the property to the west of him. And they have a house with a detached garage, and they were able to set their garage back in the back. On this particular house here to the east, the same situation. Their road comes in right through here. Their house is here, and they moved theirs abiding to the codes in place right now. They didn't ask for, they just put it, the codes are there for a reason, to keep the neighborhood intact. This picture.
Mr. Perez, can you back up to that picture
Yeah.
and tell me where is your property in relation to this?
My property is this house right here.
Okay, thank you.
And I have a wraparound porch on my house too, and it was built that way because we have a view of the river from our house, and it's built that way. And another shed right here is it's gonna look ugly. We have some restrictions when it's on the deed that says it could be a nuisance. It says, owners shall maintain their property so that it is not a nuisance to the neighborhood. Well, I feel like this building would be a nuisance to the neighborhood. The way the neighborhood is aesthetically looking today, it's going to make it look commercial. So between them, I just think there's a better way to do it. On this drawing right here, this is the property that's in we're talking about. There's 300 there's 351 feet, 334 feet of property line. That's bigger than a football field by 128 going the other way. There's different ways. You don't need to put a shed right here and block everybody's view or right on this lot 4's property line. There's got to be a way to work something out better. He could still have a shed and everybody can be happy. But just, and this here is our road. We pay for this road. We pay for it to have it paved. There's an easement with a boat ramp down here that we all maintain, all 6 properties on this lot. And that's why we live here. We don't need somebody coming in and blocking everything up. So I'm opposed to it.
All right. Thank you, sir.
Okay.
And you can submit those to the records if you wish and sign in with the clerk right here.
Okay. Thank you very much.
Yes, sir. Thank you.
Thank you.
All right. Is there anyone else here or online who wishes to speak in opposition to this application? All right. Don't see anyone. Development Services, anything further?
Nothing further.
All right. Applicant?
Hello again to my representing the applicant. I appreciate the opposition's comments in regards to the shed and the location of the shed. However, we're here discussing a variance for the setback, the front yard setback. The reason why we're asking for the 20-foot setback is so Mr. Larson would be able to drive from Linesider Drive into his detached garage. The reason why I listed why there is a hardship versus the other property owners adjacent to him don't share that same hardship is because Linesider Drive is a driveway easement, and that subjects him, that is access to the west of his property, which subjects him to a front yard setback, whereas his neighbors to the east or north or west are not subject to a front yard setback. They have they have a side yard setback that they're subject to. In regards to the accessory structure, nothing has been proposed. We're just asking for the location, the front yard setback location. We appreciate that they don't want this accessory structure to impede their view of the lake. However, you know, Mr. Larson does have a right to enjoy his property just as the other property owners in the RSC 6 district as well. Thank you.
Thank you, Ms. Mai. All right, this will conclude the hearing on variance 22-0932. All right, given that we are between cases and it's 11:53, we're going to take a short break. And we'll 7 minutes. 1 moment. All right, we're just going to take a quick break right now, and then we'll assess where we are for the remaining hearings for the afternoon. We may have to take a lunch break, but for now, would everyone please be back in your seats by 12 o'clock or so? We're just taking a quick break. July 25th, 2022 Land Use Hearing Officer meeting. And we're ready to call the next case.
Our next case is item H7, variance application 22-0955. The applicant is Timothy Healy.
Okay. Was that one continued? Yeah.
Oh,
That one was continued.
oh gosh, sorry.
It's all right.
Thank you. Excuse me. Okay, our next case is item H8, variance application 22-0998. The applicant is Karen Mathura Arthur, requesting a variance to lot development standards. Staff findings will be presented by Tim Lampkin.
Good afternoon. The applicant's requesting a setback variance to accommodate a proposed single-family home on a property zoned agricultural single-family conventional, otherwise known as ASC 1. Per Land Development Code 6.01.01 Schedule of District Area Height, Bulk, and Placement Regulations, a minimum front yard setback of 50 feet is required in the district. The applicant requests a 12-foot reduction to the required front yard setback to allow a setback of 38 feet from the east property line. The subject property is on a corner lot, and the required front yard setbacks are required on both the north and the east sides. The subject parcel's zoning requires a minimum lot size of 1 acre. The subject parcel is approximately 38,332 feet, which is shy of the required acre. However, it has been certified as legally non-conforming per NCL 10-0392, which has been placed in the case record for the subject variance. The applicant was issued an EPC violation, which is case number 2020-0225E for unauthorized fill placement and unauthorized culvert installation with associated fill in wetlands and/or other water surfaces on the property. The applicant has resolved the violation with EPC and has agreed to construct a retaining wall, again, along the western property line. Consequently, the proposed home is no longer within a wetland or wetland setback area as shown on the site plan that was submitted prior to their final approval for this variance application. That concludes staff's presentation.
All right, thank you. We'll hear from the applicant, please.
Good morning, good afternoon. My name is Karen Matura Arthur. My address is 5370 Arlington River Drive, Lakeland, Florida, 33811. The property address that is in question is 2590 Hawk Griffin Road, Plant City, Florida, 33565. I have been sworn in. Apologies for not being there in person. I am working. I am in New York currently. I am requesting a variance to section 6.01.01, a setback variance of 12 feet to the required 50-foot front yard variance. As mentioned, this property has 2 front yard setbacks. There is a private road abutting the side of the property for which I'm requesting the setback. And so I would like to change the requirement from 50 feet to 38 feet. This would allow me to place my house in the middle of the lot and not further encroach to the neighbors on the west side of the property, I believe. They have been quite disgruntled, and I am not trying to be closer to them, rather just in the middle of my property. Through the building permit application, it was discovered that this property had 2 front yards. It was believed for quite some time, even at purchase, that because of the private road on Valhalla Lane, that second setback for a front yard would not be required. I have received basically much support from all the neighbors on Valhalla Lane, and nobody has contacted me to disagree with the request for this variance. This variance is not a required variance. There are no hardships formed. It's more of a look and feel request of a variance and not wanting to be next to a disgruntled neighbor or closer to a disgruntled neighbor. That's all.
Okay, and you're the property owner and you're building your house there, is that correct?
Yes, ma'am. I am the property owner and I'm building my own house there.
Okay. And the setback, it's kind of difficult for me to tell exactly where it is. I see your survey. I see Hawk Griffin Road to the north. And you said there's another road. Is that road, which side of your property is that other road on?
So if Hawk Griffin is to the north, it would be to the east.
Okay, I see it. Valhalla.
Yes, and that is it is a private road. And for many years, the county has not maintained the right-of-way, stating that it was a private road. And the road does veer off not further up from where I'm building the house. So really and truly, the house doesn't really hit that 50-yard setback as it aligns to the road.
Okay. And you're requesting a variance. A variance has to be based on hardship. I believe you made the statement that there's no hardship. So could you explain what the hardship is? I can't grant a variance unless there's a hardship.
Sorry, maybe I should say that because of the EPC consent order, we have filled a wetland. I do not want to be on top of that filled area. If I move my house over, it would have to encroach in that filled area, or I'd have to push my house further back.
Okay, so is it your testimony that in order to construct your house on this property, it has to be situated the way you've planned it and you need a variance for that?
Yes, ma'am.
Okay. All right, do you have anything further?
No.
All right, thank you.
Thank you.
All right, is there anyone here or online who wishes to speak in support of this application? Do not hear anyone. Is there? Okay, come forward, please. Thank you.
My name is Mary Greco Smith. I live at 4801 Valhalla Lane, Plant City, Florida 33565. I have no opposition to this request. In fact, it's puzzling to me that she has that she's on a corner lot, because between her property and our private road is a ditch, a drainage ditch. She has no access to our private road, so there's no way she could even get access to our private road without our permission. It's just not feasible, and it would be going over a drainage ditch, which would not be allowed. So I don't understand the 50-foot setback on two fronts, because to me, the only front is the one facing Hawk Griffin Road, which is on the north. We have no opposition. We think that the construction of her home would be an asset to our community. There is nothing that I can think of that would be detrimental to what she's doing on her property. In years past, many, many years ago, there was a little shack on that property. So we're just delighted there's going to be a nice, new, beautiful home situated there.
All right, thank you, Ms. Smith. Would you please sign in with the clerk? Thank you. All right, is there anyone else who wishes to speak in support of this application? All right, is there anyone here or online who wishes to speak in opposition to this application? Do not hear anyone. All right, applicant, did you have anything further you would like to add?
No, but I appreciate your consideration in getting this all resolved and getting my house built. It has been a long journey of over 2 years to get to this point.
And I'm sorry I skipped development services. Let me go back to development services. Did development services have anything further?
We don't have anything further.
All right, thank you. Applicant, just a question about Ms. Smith. pointed out that there was a drainage ditch, and she described it, I believe, as being between your proposed house and Valhalla Lane. Do you have access to Valhalla Lane from your property?
No, ma'am.
And is that drainage ditch area, is that the area that you were speaking of a moment ago about fill dirt and you're trying to avoid it?
No, that's the other side. That's why I'm actually moving the house closer.
Oh, okay.
That's on the other side. Yeah.
I see it. I'm looking at your site plan. I see it. Thank you. All right. I don't have any more questions for you. Did you have anything else?
Ma'am, thank you.
All right. Thank you. So that will close the hearing on variance 22-0998.
Our next case is item H9, variance application 22-1009. The applicant is Hamid Kashani, requesting a variance to accessory structure requirements and a variance to lot development standards. Staff findings will be presented by Sam Ball.
Good afternoon, Sam Ball, Development Services. The applicant is requesting setback variances for an existing detached garage and single-family dwelling on residential property zoned PD 80-0046, also located at 2036 Gregory Drive. According to the certified general site plan for PD 80-0046, single-family dwellings may be developed as zero lot line units with zero side yard setbacks on one side of the lot and a minimum separation of 10 feet between buildings. The home on the subject property and the neighboring lots were developed as zero lot line units. The home on the subject property has a zero setback from the northerly side of the lot line, as does the home on the adjacent lot to the south. Therefore, a minimum side yard setback of 10 feet is required from the south lot line of the subject property. The applicant requests a 0.9 foot setback to the required south side setback to allow a 9.1 foot setback from the south property line. Per LDC section 61104C2, accessory structures may occupy required side yards provided that such structures are more distant from the street than any part of the principal building on the same lot and any lot abutting the said required side yard, provided, however, that such accessory structures are not closer than 3 feet from any side lot line, including architectural features such as cornices, eaves, and gutters. In the subject case, the detached garage is closer to the street than a portion of the home on the lot. Therefore, the detached structure is subject to the same setbacks described above for the single-family dwelling. The applicant requests a 9.6 foot reduction to the required south side yard setback to allow 0 feet setback from the south property line as measured to the structure's eaves. Additional findings, so the property appraiser's records and aerial photographs show the single-family home on the property was built in 1986, and the detached garage was built after January 25th, 2020. The applicant has been cited for building the garage without permits. If the requested variance is approved, the applicant must obtain an after-effect building permit. That concludes my report. Thank you.
All right. Thank you, Mr. Ball. We'll hear from the applicant, please.
Hello, my name is Hamid Kashani, 2036 Gregory Drive. I'm the original owner since 1985. And case number 22-1009. And as you well know, and he alluded, these are zero lot line, which means the width of the lots are designed in such a way that majority of homes, they only have room for 12-inch to the garages and the garage width, and then the walkway, and then you have the 2-bedroom homes. These are all designed. And I'd like to I'd like to bring your attention to Exhibit A, which was handed or given to the county. And as you observe, right there, 1984, I did initial there, but I used magnifying glass, and it's hard to read that, but this was a site plan that was approved by the county. And please observe, this is the house, which is hatched, you know, in engineering term, they use the hatched area for concrete homes. And this is right there is driveway and walkway and the original intent of the garage. And we did nothing but put the garage in the original, which I was under the impression that this was approved by the county. Now,
Mr. Kashani, where did you get this document?
I got it from the county officials, Hillsborough.
Okay, what was it? What is it exactly? It's apparently, it's an exhibit out of something. What is it an exhibit from?
Okay, I asked for public records for the entire neighborhood, and these are all the documents that ever was put together for that Pine Lake subdivision properties. And these are all from county, and you can, and maybe Sam can testify to that.
Okay, are you going to submit those into the record?
I can submit the exhibit A and B, yes.
Okay, thank you.
I have a copy of that.
And so you've owned this house since it was constructed, is that correct?
Yes, ma'am.
All right. And the garage was just recently constructed there, is that correct? Within the last few years?
We applied for a permit on 6/11/2020
You applied for a permit for the garage?
for the garage, yes, to build a garage. And I am a structural engineer, and I made sure that everything, all the hurricane clips, all the trusses, everything is according to the code.
Was a permit granted?
No, because of the variance, they told me, and I don't understand, that's the hardship, and I don't understand why I'm here, to be honest.
Okay, well, let's just back up a minute. You applied for a permit to build the garage.
Yes.
And the permit application was denied?
Denied.
And you were told to obtain a variance, is that
Yes.
correct?
Yes.
All right, and you built the garage anyway?
I built the garage prior to that because I was under the impression that with this is the location. And I checked for the footing, the footings were there. The lady who sold us the house at that time, they told us that you can have the garages, you can build your garages. These are all grandfathered. And I have Exhibit B that if I can show you, and again, this is county, Hillsborough County documents. It's not, the dates and all these are there. And this shows the intent of the neighborhood. You see the garages here? That's property.
Mr. Kashani, do these other properties in your neighborhood have detached garages?
Oh, yes. I have pictures. This is my neighbor right now. This is attached to my house, to the right there. This is attached to my roof. And then Exhibit C or D shows my garage, which is way away from the neighbor.
Mr. Kashani,
Yes.
when did you construct your garage?
I'm sorry?
When did you construct your garage?
That was sometimes before, I think, early 20s. And I tried to get hold of, because of the COVID, there were a lot of problems with communicating with the county officials.
Okay, I'm not clear on that, though. You said you applied for a permit in 2020, but your garage had already been constructed. So when was it
Yes,
constructed?
It was.
Was it constructed in 2020 or sometime
No,
before then?
before, maybe, I don't remember the exact time, but it was right, maybe January of 2020. And then I was told that I need to have a permit for the garage. Then I applied 6/11.
Okay.
And then if I may show you some other examples. This is another in the neighborhood. There's another one, another one, another one. And here's another funny one because the garage is being used as a living area. And look at this one. These are all designed and permitted by Hillsborough County. Look at this. I can go on and on and on and on. There were 31, between 30 to 31 homes that were permitted and allowed to build.
And when you constructed this garage, is there electrical service to the garage?
No.
There are no lights in the garage?
But now I have it.
And there's I assume you have a garage door with a...
Yes.
So your garage structure has electrical service?
Now it has, and I'm trying to apply for permit, but they told me I need to do this, which I respect that. You know, I respect, you'd be surprised how many people were driving by and gave me thumbs up and encouraged me for what I've done to the neighborhood. And, it's just, I don't want to show you some nightmare in the area and what I have improved the neighborhood. This is.
Okay, and so you're requesting a variance to accommodate the portion of your home and also for the detached garage, is that correct?
Yes, portion of the home, I think Sam brought it to my attention, which was like on angle. Yeah, right here. If you look at this clip right there, which is about maybe 9 inches closer to this, and this was permitted and constructed, the original. I don't know why I have to ask for it, but I did ask for it.
Okay. All right, is there anything else?
I just want to tell you that, I feel like I have done great job to bring and I understand about the permit, believe me, and I've learned my lesson about that. So I'm obeying that. I love this country because of the laws and regulations. So I respect that and I learned my lesson.
Okay. All right, thank you. Please, anything you want to submit to the record, leave it with the clerk and be sure and sign in.
All these I submitted already. Should I still?
If you have submitted them already, you do not have to, but if you wish to, you can.
No, I have submitted it.
Okay.
That's it.
All right, thank you, sir. Is there anyone here or online who wishes to speak in support of this application?
Hi, my name is Angel Santiago. I live at 2038 Gregory Drive, Tampa Bay, well, in Tampa. I'm actually the neighbor. I'm in favor of what he's done aesthetically to the neighborhood. I've been living there for over 6 years or more. And has done wonders as far as, the quality of life as well as bringing the property values up. So I can't compare my garage to his because it's much better looking than mine, but I definitely appreciate what he's done. He has other properties in the neighborhood as well, and he's doing the same thing as well. upgrade the neighborhood. So I'm definitely in favor for what he's doing.
All right, Mr. Santiago, do you have a detached garage and a similar?
My garage is attached to his roof.
Testing 1, 2, 3, 4, 5, 6.
Have you observed other properties in your subdivision that are constructed with, similarly with homes and detached garages like this?
Absolutely.
Okay.
Absolutely.
All right, is there anything else you wish to add?
No, that's it.
Okay.
All right.
Thank you, sir. Be sure and sign in with the clerk.
All right.
All right, is there anyone else here or online who wishes to speak in support of this application? Don't hear anyone.
One person online.
One person online to speak in support?
Oh, sorry, in opposition.
Okay, I'm going to ask that next. All right, is there anyone here or online who wishes to speak in opposition to this application?
Yes.
All right, we have someone online. Go ahead, sir.
My name is Antonio Walker. I live at 2034 Gregory Drive. His home is directly next to mine. As a matter of fact, properties he owned actually border both sides of my home. I've been living in this house for approximately 1.5 years. So I purchased the home just after he had began construction and saw its completion. My issues are that the garage was built without permitting. It does have electricity. When it is that they asked him to put in a permit, he manufactured a permit from nowhere and just turned it in, which is like fraud. It could be a danger to my home and to other people's homes. I'm not overly concerned with other people's garage that were previously built, more so just the fact that he's had no respect for the current rules and laws and that he thought that he could just go around them any way he saw fit. And if something was to happen to my home as a result of this work that he's done, without permits, without inspections, without any of those things, I could lose my first home because of his choices, because of his negligence.
All right. Anything further?
Yes, the garage is currently 1 foot 7 inches from my house. That is all.
From your house?
Yes, ma'am.
Okay. All right. Thank you, sir.
Thank you.
Is there anyone else here or online who wishes to speak in opposition? All right, don't hear anyone. Development Services, anything further?
No, ma'am, nothing further.
All right, applicant, did you have anything further you wish to add?
When we did the garage, this gentleman was not the owner.
Mm-hmm.
And I think and we put a gutter and the backsplash, like a splash guard. And there is absolutely, I have seen during storm, and we opened the one side of the gutter completely open, and there's absolutely no water going to his property, even though the other properties are designed like this. Like I said, the original intent of the garages are exactly the way I have it.
Okay. Thank you, sir. Thank you. All right, this will close the hearing on variance 22-1009.
Here, our last variance is item H10, application 22-1055. The applicant is Mike and Luann Leahy, requesting a variance to fence requirements. Staff findings will be presented by Isis Brown.
Good afternoon, Isis Brown, Development Services, reporting case 22, variance 22-1055. The applicant requests a height variance to accommodate a proposed fence on property zoned agricultural single-family conventional 1, ASC 1. The variance per LDC section 6.0702 .C.2, fences in agricultural districts shall be regulated in the same manner as fences in residential districts, except under certain circumstances that do not apply to this case. Per LDC section 6.07.02 2.0.c.1, a maximum height of 6 feet is permitted for fences, excluding those located in required front yards and under certain circumstances that do not apply to this case. The applicant requests a 2-foot increase to the maximum permitted height to allow a height of 8 feet for a proposed concrete and wrought iron fence in the existing fence located in required front yard, as pointed out on with the green graphics here. The findings: the subject property is located along a portion of Dover Road that is designated as a rural scenic corridor per LDC section 6.06.06.1.2.a. A 30-foot wide scenic easement must be left in a natural state along the roadway's frontage. The applicant has not requested a variance to this requirement, and as shown on the revised site plan, the proposed wall will be constructed outside of the scenic easement area. The second finding: the subject property is comprised of 2 parcels that are zone ASC1, which requires a minimum of lot size of 1 acre and a minimum lot width of 150 feet. However, the eastern parcel, which is the front parcel, under folio number 84648.0028 is approximately 1.71 acres in size and only 143 feet in width, therefore is non-conforming. However, it has been certified as a legal non-conforming lot per NCL 22-1056 and is in the case record. I am available for any questions.
All right, thank you. We'll hear from the applicant then.
Good afternoon. Mike and Luann Leahy, 2544 North Dover Road. And we're looking for a variance to the fence requirement, 22-1055. I would like to say thank you to Isis Brown and to Claire Odell for their help in kind of getting us here. We actually applied for a building permit for the fence, and you know, the non-conforming lot and the variance were kind of outfalls of that. So we're appreciative to them to help us get through it. You know, as far as, you know, one of the issues, obviously, as you mentioned, is hardships. And, you know, one of the things that we're looking for out of this is security for our property. And, you know, we've had an attempted break-in. And so it's different where we are. You know, we're out in the country. We don't have the benefit of having a gate and, you know, being behind a wall and that kind of stuff that is afforded to a lot of subdivisions. And so that's kind of what we're looking to do here. And so I do have a picture that is not in record that I can use your kind of awesome machine there. I'll try it. How did you do that? So when we talk about an 8-foot, you know, wall, it's really a 3-foot base and then 5 feet of wrought iron on top of that. So it'll be mostly opaque, you know, but we are looking for the additional security.
Okay, and let's see, just 1 second. So under the code, you're allowed a 4-foot fence in your front yard. Is that correct?
Correct, 4 feet. And then the columns, as I understand it, can be 5. Our problem with that is somebody can jump a 4-foot fence pretty easy. We're 400 feet back from the road. So, you know, during the attempted break-in, it took 30 minutes for the sheriff's deputies to show up and everything was done at that point. So that's really, you know, part of our issue is we're thankful, obviously, that we're in the country, but we're in the country. So, you know,
So the columns are going to be how high?
8.
8. Okay. And then the fence itself?
The fence itself is 3 for the bottom
Right,
part and then
right.
5 for the wrought iron.
Okay. So the whole thing, so it's 8 all the way across.
Yeah.
Okay. All right. Some reason I'm seeing in the staff report a maximum height of 6 feet.
Yeah, that was,
Mr. Hisney, am I reading that correctly, or is it 6 feet or front or 4 feet for this property in this case?
Yeah, in this case, the fence is going to be set back 30 feet from the roadway.
right, to comply
Correct.
with the
Yeah,
30
and
foot
so the
rural.
front yard is 50 feet. So the maximum height that's permitted is 4 feet and required. So they're looking for a 4-foot increase
Okay.
to allow a height of 8 feet. Now, is the fence going to extend down either side property line?
Eventually on the north side, there's already a pretty strong tree line.
Yeah.
On the,
And on that, would you want that to be 8 feet in height as well?
no, there's enough trees there where
We would
nobody could
keep it at
really.
6. Yeah, because
Yeah.
once you get past 50 feet on your setback from the road, there you're allowed a 6-foot height by right. So you're not looking to go above 6 feet.
Right.
All right. Yes, ma'am. Sorry. The fence is in the required front yard, limited to 4 feet.
Okay. So the variance is actually for a 4-foot variance to the fence.
Correct.
Okay. Thank you. So that's all we're looking at today on the front. The frontage of the property, a 4-foot variance on the height for the fence to get an 8-foot fence.
Correct.
And your hardship criteria it's related to security because.
Right. Our feeling is that with a 4-foot fence, somebody could hop over it and do whatever harm they're going to do. And we get a fair amount of folks that pull into our driveway and for various reasons, whether they're case and joint or, you know, just honestly turned around and need to turn around, they can do that. But, you know, there's enough of that where there's a concern about security.
Okay. All right. Thank you. Anything further?
Yes, I would like to speak. I'm Luann Leahy. And
state your name and your address.
Sorry, Luann Leahy. I'm Mike's wife, 2544 North Dover Road, Dover, Florida, 33527. I lived on this property for almost 52 years. And I come from a time when I was younger, you know, you could leave your doors unlocked in the country. Didn't have too much concern about others breaking in and entering and doing harm to us. Through the years, as you can see, times have changed. And you see shootings in schools and churches and malls and drive-by shootings and robberies. And it's gone out of control. And as my husband mentioned, you know, we did have an attempt to break it. It took a while for the police to get there, which we're very grateful they showed up anyway, because we support the police. And, but you know, you wonder when that happens, when are they going to come back again? You know, they invaded our privacy. We're an acre and a half off the road. And for someone to come back to our home to try to take what we have worked so hard for, it's scary. And if my daughter lives at home and she's afraid to be home by herself, I'm afraid. I'm a stay-at-home mom and I do a lot of volunteer work, and I'm afraid to be home by myself. I frequently see cars coming down our driveway, an acre and a half off the road, and do a circle around our front door and head back. In fact, one day, just about a week or two ago, I was driving home. And I see this gray car pulling into my driveway. And I'm like, oh my goodness, and no one's home. So I pull in. This car proceeded to go in front of pulled all the way back to my house, started coming back up to my home. And I pulled in, I said, can I help you? He said, oh, do you live back there? There were 2 people in the car. I said, I do. He said, well, we're looking for a grocery store. I said, there is no grocery store back there. Then he proceeded to pull out a chain and try to sell me jewelry. I said, no, thank you. Politely, I said, no, thank you. And I proceeded to tell him where the next grocery store was. That's scary. They're able to get back to my home, Who knows what they were doing? And we have cars all the time coming in to all the way back to my house, making the U-turn and coming back out my driveway. So I live with fear every day of my life that someone's going to come back. And we work so hard for what we have. We're law-abiding citizens. We pay our taxes. We give back to our community. We help those in need. That's who we are. And so I just ask you, please grant us the variance on our fence so we can feel secure at home and not have to worry about people coming back and trying to do us harm and taking our property that we work so hard for. So I just ask, please grant us this variance so we can feel safe. And if you can't feel safe at home, where can you feel safe at? You know? Anyway, thank you so much for your time. I'm sorry I'm talking so much.
Thank you, ma'am. Please sign in with the clerk's office. And if you wish to submit those photographs, submit them to the clerk here.
Thank you again for
Yes.
your time.
Thank you. All right, is there anyone here or online who wishes to speak in support of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, I don't hear anyone. Development Services, anything further?
Nope. No, ma'am.
Okay. All right. Applicant, did you have anything further you wanted to add? Wait till you get to the microphone. Thank you. Come to the microphone, please.
Sorry. We have had several neighbors in approval of us building the fence, and I just want to make sure they did send it through email. So I'm not sure if that was received. I just wanted to make note of that.
Okay. Thank you.
I'm sorry. Thank you so much.
If it is, it'll be in the record and I'll review it.
Thank you.
All right. All right, this will close then the hearing on variance 22-1055. All right, we have three special use requests coming up and an appeal. We're going to take, just for everybody's comfort, a 30-minute break for you want to get something to eat or grab a power bar, and we'll be back in 30 minutes, okay? So we're recessed for 30 minutes. welcome back. We're reconvening. This is the July 25th, 2022 Land Use Hearing Officer meeting. And we'll call the next case, please.
All right, so that earlier before the break, we had concluded our variances. We're now moving on to section J of the agenda, which are special uses. First case is special use 22-0476. The applicant is Fat Beet Farm Marketplace and Bakery. They are requesting a 2 COP alcoholic beverage permit, which requires waivers. Staff report and recommendation will be presented by Israel Monsanto following the presentation by the applicant.
All right, we'll hear from the applicant.
Good afternoon. My name is Alyssa Tidmore, and I'm a paralegal with the Tiller Law Group. We're located at 633 North Franklin Street, Suite 625, Tampa, Florida 33602. Our firm represents the applicant, Fat Beet Farm Marketplace and Bakery, LLC, located at 13802 and 13830 West Hillsborough Avenue, Tampa, Florida 33635. Our client operates a bakery and farm consisting of approximately 11.5 acres. The business is family-friendly and educates the community about sustainability and the potential of farming in Florida. Further, our client provides wholesome, thoughtful, and scrumptious food to the public and a memorable space for unforgettable events. Applicant additionally offers walking tours that include their vegetable gardens, composting and vermiculture, chickens, biodigester, bees, microgreens, aquaculture systems, wetland and coastal preservation areas, and more. They also offer field trip opportunities to the local school systems to provide students with an immersive experience learning where their food comes from. Currently, the business operates with a 2 APS license, which allows for the sale of packaged beer and wine for consumption off the premises only. The applicant wishes to increase its license to a 2 COP to include the sale of beer and wine for consumption on the premises, with the idea that patrons can have a beer or a glass of wine with their food while sitting at one of the tables under the covered pavilion or participate in one of the guided tours of the farm with their drink. The applicant is requesting a distance separation waiver for the residential properties located at 12917 State Street and 13025 State Street, as the properties are within the 250 feet separation requirement. However, the proposed use will not have a negative impact on the surrounding land use areas, as applicant's business is facing West Hillsborough Avenue and the residentially zoned properties are facing State Street. The normal route of travel is approximately 2 miles, as the area behind applicant's proposed structure is heavily wooded and there are no straight line roads connecting the residentially zoned properties and the applicant's proposed location. In addition to the heavily wooded area, the properties are separated by a body of water as well. Further, applicant is requesting a second waiver for the number of alcoholic beverage permits located within 1,000 feet of the proposed wet zone, as there are currently 4 approved alcoholic beverage permits within the distance requirement. However, the location of one of the approved alcoholic beverage permits does not utilize its permit anymore, as it now operates as Leslie's Pool Store. If this proposed wet zone is approved, this will allow the applicant to increase its revenue, and in turn, the community will greatly benefit from this business's dedication to Florida farming and sustainability. Thank you.
All right, thank you. And please sign in with the clerk. All right, Development Services.
Good afternoon, Israel Monsanto Development Services. As the applicant has stated, they're seeking approval for a separation waiver for a 2 COP alcoholic beverage permit for a mixed-use restaurant, farm, and produce processing operation on 13830 West Hillsborough Avenue. This request would allow the sale of beer and wine for consumption on and off the permitted premises. This site is zone plan development 180681, which allows the host use and the proposed wet zoning. Per the certified site plan of the PD, restaurant uses, a pavilion, a grass event area, and a food production building are located on its northernmost portion of the site along Hillsborough Avenue. And then the southernmost portion of this PD is zoned for farming areas and 2 food production buildings. There is a 5-foot wide walkway that connects both areas. And that's shown on the staff report. And because the farming area of the site is agriculturally zoned, this code section 61111A1 requires wet zoning, if approved, to be limited by condition to the specifically approved host use of the PD. As the applicant has stated, and according to the revised survey, the proposed wet zone area will be 11.55 acres in total size and would cover the entire PD district. Per the code section 61111D4, there are 2 distance separations requirements that would not be met. And also that's in accordance with the survey. Those is the distance from proposed structure to residentially zoned property, which shall be 250 feet. According to the survey, 1 residential parcel zone PD is located adjacent from the southwest portion of the subject, and that's tag number 6 in the survey. And the second residential parcel is zone RC3 with a mobile home overlay, which is adjacent to the southeast corner of the subject site. That's tag number 5 of the survey. Therefore, the applicant is requesting a 250-foot waiver separation. The other waiver that is not, the other waiver for the other distance that's not being met is that there shall be no more than 3 approved number of alcoholic beverages as listed in the code. And there are more than 3 in this case, as shown on the submitted survey. There are 4 approved alcoholic beverage uses within 1,000 feet, which falls under those categories in the code. There is 1 2-cup, 1 3PS, and 2 more 4-cups, and those are all tagged in the survey. Development services staff has reviewed the applicant's justifications and finds them approvable. The residentially zoned parcels are largely to the south of the proposed wet zoning and generally separated by heavy vegetation and a body of water. There is no direct connection, vehicular or pedestrian, between the 2 sites, between the subject site and the residentially zoned properties. The actual walking distance between the frontages of the subject site and those residential properties are about more than a mile away. And staff recommends that the sale of the alcoholic beverages be limited to a specific location in the northern portion of the PD, thereby limiting the farm areas to consumption only. The immediate area consists of a mix of commercial retail and restaurants. The requested AB license is typically found in commercial corridors, such as this area. Additionally, the other wet zoning of certain types are located in shopping centers that have no functional relationship with the subject operation, which should mitigate the cumulative impact of these wet zonings. Staff recommends that the proposed wet zoning is approval. It's approval with conditions. This wet zoning does not pose significant impacts on surrounding land uses, and the necessity of the specified distance separations requirements is negated by the circumstances noted by the applicant and by staff. We recommend the conditions, and the conditions are stated in the staff report. There are 4 conditions. The sale of the alcohol beverage shall be limited to the 4,500 square foot pavilion, grass area, event area, 6,000 square foot restaurant on the northern part, 24,000 square feet food production and restaurant retail buildings also on the northern parts as shown on the general site plan of the PD plan. Consumption of the alcoholic beverage shall be permitted throughout the whole district. As the applicant noted in their justifications, staff has added a condition for no amplified music. And the other condition deals with the event that the farm areas shown on the PD plan are reduced or eliminated by modification of the PD in the future. The consumption of the alcoholic beverages in said modified area shall no longer be allowed under this alcoholic beverage permit, therefore requiring a new AB permit. There is an existing 2 APSIS in use, and shall this special use be approved, the existing APSIS shall be rescinded. And we're available if you have any questions.
Thank you, Mr. Monsanto. All right. Is there anyone here or online who wishes to speak in support of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, don't hear anyone. County Development Services, anything further?
No, ma'am.
All right, and applicant, did you have anything further? No? Okay. All right, thank you. That will close then the hearing on special use, AB 22-0476.
Okay, our next special use is item J2, application number 22-0861. The applicant is AmVets Post 26, Valrico. The request is for a 11C social club alcoholic beverage permit with separation waivers. Staff report and recommendation will be presented by Sam Ball following the applicant's presentation.
Thank you, Mr. Hisney. Applicant?
Can you hear me?
Yes.
Okay. How are you today?
Fine, thank you.
And yes, I'm here with AmVets Post 26 Valrico, located at 221 South Dover Road in Dover. There's two items that we're requesting. The first is a waiver for 11C Social Club, alcohol beverage. Yes, ma'am.
I'm sorry, we need you to
I
state.
forgot my name.
Yep, thank you.
Sorry, I'm just on a roll. Dixie Liberty, 200 Adams Avenue, Hopkinsville, Kentucky, 42240.
Okay, go ahead.
Okay, I have requesting two items. The first one is a waiver for 11C Social Club alcohol beverage permit to allow for the sales of consumption of beer, wine, and liquor on the permitted premises only for members and their guests for existing charter club. Separation from residentially zoned property is 250 feet. The residence is separated from the site by Dover Road, a major roadway. The homes are separated by a 6-foot high masonry wall along the roadway. The AmVets does sit back off the roadway, sits back far enough away. The distance to the residential is 109 feet, asking 141 feet. The nearest resident home is approximately 370 feet. The second one is extension of premise. I call it extension of premise. The AmVets would like to get the wet zone for 78,855 of their property, all of which is outdoor area except for 4,750 square feet of the indoor area distributed among several buildings on the parcel. There is an existing 11C social club wet zoning on the property. It's AB 1490. Approval for 8218 square feet. The total is 41 square feet of indoor area and 4068 square feet outdoor area. Total is 8218 square feet. The parcel is zoned BPO, which allows membership organization and consideration of the proposed wet zoning. Also, there is restricted hours that was put down for this. It's 11 a.m. to 11 p.m. Monday through Sunday. And no one has contacted me on this. Also, if approved, rescind AB 191490. And this will not have any significant negative impacts on the surrounding property. You have any questions?
I have no questions for you, Ms. Liberty. Thank you.
Thank you, ma'am.
Okay. We'll hear from staff.
Good afternoon, Sam Ball, Development Services. As we stated, the applicant is seeking approval of a distance separation waiver for an 11C social club alcoholic beverage permit to allow for the sale and consumption of beer, wine, and liquor on the permitted premises only to members and their guests for an existing charter club, AmVets Post number 26, 221 South Dover Road. The proposed wet zone area covers 78,855 square feet, all of which is outdoor except for 4,750 square feet. There is an existing 11C wet zoning on the property that covers 8,218 square feet. of indoor and outdoor space. The application includes a statement from the applicant that alcohol sales and consumption will be limited from 11 a.m. to 11 p.m. The parcel BPO zoning allows a membership organization and consideration of the proposed wet zoning. The distance from the proposed structure for residential, according to the code, the distance from the proposed structure to the residentially zoned property shall be 250 feet. According to the survey submitted by the applicant, the request does not comply with this requirement. There is a single-family subdivision 250 feet to the east across Dover Road. The applicant requests a 141-foot waiver to the required 250-foot separation from the residentially zoned property to allow separation of 109 feet. For staff findings, the single-family subdivision that is located in the 250 feet of the proposed wet zone area is separated from the site by Dover Road, which is a major collector roadway. Additionally, the single-family homes are screened by a 6 to 8 foot wall, 8 foot high masonry wall along the roadway. The normal route of travel from the post buildings to the nearest residential home is approximately 370 feet, and the subdivision is a gated community. A large portion of the outdoor area in the proposed wet zoning is located on the west side of the subject property behind the outpost building and approximately 250 feet or more from the rear yards of the nearest single-family home in the subdivision. While the adjacent property to the west is a 340-foot wide TICO right-of-way, the adjacent property to the north is zoned AS1 and is vacant, while the adjacent property to the south is also zoned AS1 and occupied by a mobile home. However, because the property is agriculturally zoned, no separation waiver is required by the proposed wet zoning from that property to the south. As proposed by the applicant, the sale and consumption of alcohol beverages will be limited to the hours from 11 a.m. to 11 p.m. daily. This is notably less than the hours permitted by the Land Development Code, which are Monday through Saturday, 7 a.m. to 3 a.m. the next day, and Sunday from 11 a.m. to 3 a.m. the next day. The proposed wet zoning will replace the post-existing 11C Social Club wet zoning, which also required approval of a waiver from the residential subdivision. Staff has received no objections from the residents of the subdivision or other parties. For reasons discussed above, staff finds the proposed wet zoning does not pose significant impacts on the surrounding area, and the necessity for the required separation from the subdivision is negated. Therefore, staff finds the proposed 11C alcoholic beverage permit to be approvable, subject to the conditions that the sale or consumption of alcohol beverages shall be limited to the hours from 11 a.m. to 11 p.m. daily, and upon approval of special use AB 22-0861, the existing 11C wet zoning on the subject property, AB 19-1490, shall be rescinded. Approval is based on the revised wet zone survey reflecting a total wet zone footprint of 78,855 square feet, as shown on the revised wet zone survey received July 5th, 2022. That concludes my presentation.
Mr. Ball, just to clarify, the staff report says the proposed wet zoning footprint is 78,855 square feet. And I guess that's the entire property, but it appears the survey, well, that might be consistent with the survey, but the applicant's letter says they're requesting the whole property to be wet zoned, and says the property contains 104,572 square feet, more or less. So is there a discrepancy in the size of the property? And maybe the applicant can speak to this on rebuttal, but I'm just asking staff right now.
No, the wet zone survey, the revised wet zone survey should show a portion of the property that's kind of been removed from the wet zoning area. It covers like the northeastern portion of the site. It's a parking lot and like a driveway entrance.
Okay.
So there's a section of the property that's been removed from the wet zoning.
Okay. Thank you for clarifying that. And the applicant can address that too on rebuttal. We're going to go to public comment at this time, though. Is there anyone here or online who wishes to speak in support of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, don't hear anyone. And development services, anything further?
I know, ma'am.
Oh, but just again to touch on Sam's last point, the wet zoning, when it originally came in, was going to cover the entire site.
Okay.
During the review process and discussions with staff, they reduced the size of it to exclude the parking area and a little bit in front of the buildings. So what you're seeing is the revised survey.
All right, thank you, Mr. Hisney. And applicant?
Yes, ma'am. We went ahead and we took that partial off. We took the parking lot off.
All right, so then the accurate square footage for the AB special use area is as it's presented in the staff report, that square footage.
Yes, ma'am.
Okay, thank you. Anything further?
No, ma'am.
All right, this will close the hearing on special use AB 22-0861.
Our final special use today is item J3, application 22-0826. The applicant is James Johnson of Schutz and Bowen LLP. They are requesting a special use permit for a wireless communications facility, as well as a variance to buffering and screening requirements. Staff report and recommendation will be presented by Israel Monsanto following the applicant's presentation. Additionally, Planning Commission staff will be rendering comment on this application.
Thank you, Mr. Hisney. Applicant?
Hi, good afternoon. James Johnston with Schutz and Bowen, 300 South Orange Avenue on behalf of the applicant. And I've got also with me today Steve Hutchinson with Tech Tower, Santiago Torres, who's a Verizon RF engineer, and he's actually going to be getting up to give a brief presentation kind of midway through my presentation, and then Megan Markham also from Verizon. And so, as mentioned, we have applied for a special use permit. It's for a 160-foot tall monopine communication tower and accessory equipment. It's within a 100 by 100-foot lease area on the much larger parent parcel. We also have a variance from the Type A buffer requirements, basically on the west and east side of what's being the west and north sides of the tower compound, and I'll explain that a little later on within the 100 by 100 foot lease area. And I've got some pictures here if I can access the Elma. Okay. Can I use this microphone? Okay. I wanted to start with that, which is a picture of the parent parcel, which is owned by Bay Life Church of Brandon Incorporated. It's a functioning, operating church. As you can see, it's on a larger parcel, 26.25 acre parcel. It has ASC 1 zoning, and based on the zoning and the, we have to get a special use permit for the communication tower. The height is an allowable height. The code also requires a tower in this zoning to be camouflaged. We have proposed a monopine, which is a tree type camouflage, which is under the code an acceptable camouflage type for this zoning category. And really quickly, just zoom in a little bit. And I'll show the site plan, but the tower is basically going in this area. Whoops. This area, there's a retention pond. There are actually two retention ponds there. And so it's going in one of those areas. And because it's in the retention pond, the way the tower is, the accessory equipment will actually be located on a platform because to keep it out of any, water, obviously, in the retention area. But the accessory equipment will be screened with an opaque vinyl fence, the whole platform, which meets the screening requirements. But the buffer requirements, again, I'll show you in a minute on how we're not meeting those or why we're requesting the variance from those. But here, as you can see on the property, the tower area is right here in the northwest corner of the large retention area. I think it's important to note that the code requires a tower to be set back, the zoning requirements, unless it abuts up against residential developed or zoned property, in which case it has to meet 100% of the tower height. And so the closest property to the south is residential, but the tower is going to be 288 feet from that, from the closest property line. So we're over 150% of the code required setback for that. And then it's 451 feet from the north property line, 518 feet from the east property line, and over 1,000 feet from the west property line. And then this tower will be owned by Tech Tower and with Verizon Wireless as the anchor tenant. And you will hear from Santiago in a minute from Verizon RF explaining, the need for the tower and the tower height, why it needs to be 160 feet tall in order to serve the area. There is a existing coverage and capacity gap in the area for Verizon, and so this tower is needed to serve that. And I think, and I'll address some of the residential comments that were submitted to staff in a minute, but I think one thing is important to point out, there were some comments talking about the tower being 100 feet from the property line and collapsing on homes and things like that. And I think they were mistaken. They thought this box right here was the tower location. That is actually a separate tax parcel that is also owned by the church, but that is not where the tower is going, as pointed out. It's going in this 100 by 100 foot lease area. And other ways we meet the code, the code requires co-location, that the tower will allow co-location in order to prevent the proliferation of towers in the area. And so this will be designed to, I believe, handle at least two other communication sets of antennas from other providers. We sent out the notice as is required by code to other providers, letting them know about the tower for opportunities for co-location. And then, we've also provided evidence from the FAA and the Hillsborough County Aviation Authority that it's no hazard to air navigation, the height of the tower. Also based on the tower height, no lighting will be required, which I know is a lot of time a concern of surrounding property owners. And then the county had an outside RF consultant who, reviewed this site. And I think he also confirmed in the report that the tower will provide a substantial improvement to the coverage in this target area. So at this point, I'd like Santiago Torres to come up briefly. He's with Verizon RF Engineering, and he can give a little RF information.
Mm-hmm. Good afternoon. Santiago Torres, 7701 East Telecom Parkway, Temple Terrace, Florida, 33637. I'm a senior RF engineer for Verizon, and I'm just here to kind of go over the current coverage that we have in the area and what the tower would help with. I'm going to use the Elmo as well. Sorry, is this on? Yeah. So what I have here is maps that were already submitted. This is actually from the third-party consultant that the county used. This is in their presentation as well. But basically what I have here is what we call our AWS LTE coverage. This is basically 4G coverage, and AWS would be the frequency that we use for our 4G capacity, right? The areas in green here is what we consider reliable coverage, and then the areas in red are unreliable. Basically, as you can see, the tower that Tech Tower is proposing is located in existing unreliable coverage right over here. If we were to go on this tower at the height that we're proposing, we're going to be able to solve a lot of the indoor coverage and capacity issues for the residents in this area. We will have 3 sectors on this site, basically pointing into this neighborhood here to the northeast, into this gap over here to the southeast, and then directly west into this neighborhood as well. As James Johnston already spoke about, there's an existing tower located in existing reliable coverage. So the main difference between the 2 locations is there's already an existing carrier on this site, so the next height available for us would be around 145 feet. And at the Bay Life Church location, we're going to get 155 feet. Additionally, there is a significant elevation difference between the 2 locations. It's going to be around 40 feet difference. So us going in the proposed tower, we're actually about 50 feet higher and above sea level elevation, which allows us to provide better service. And that's why this location was chosen over anything that's existing. And I think that sums it up. Thank you.
Thank you, sir.
Thank you, Santiago. I think there were other issues raised by some of the neighbors and comments received about RF emission and health issues. And I think as you've dealt with towers before, you know that health issues are not something that can be considered as part of a zoning approval. They've been preempted by the federal government. But that being said, obviously the FCC set standards for towers and antennas and RF emissions, and that these will have to be permitted and meet all of the FCC requirements. And in fact, typically in a tower, the antenna is operated at a fraction of the guidelines set by the FCC as far as RF emissions. So I just wanted to point that out because I think those were some concerns raised by the residents. Another issue raised was kind of property values and aesthetic issues. And so I think it's important to note that your county, the Hillsborough County Code, has built-in protections from surrounding neighbors. One, the camouflage requirement, which we are meeting with the monopine. Also the setbacks if you butt up against residential, which we are again 150% of, well over any, meeting the setback requirements. And then also screening, we meet the screening by providing the vinyl fence around the tower compound and equipment. And because we know that there are questions on property values, we reached out and had a property appraiser, David Talby, prepare a report. He is an MAI appraiser. He has 30 years of experience. I have his report, which I will submit to the clerk with an affidavit from Mr. Talby about the report. And he's done numerous studies on behalf of local governments, property owners, communication providers about this specific issue. Does proximity to communication towers impact property values? And as you'll see in the report, the summary shows, and all his studies show, that there is no market evidence that there are measurable impacts to property values based on proximity to communication towers. I think he has like 15 different tower locations where he shows this in this very detailed report. And in preparing the report, he looks at sales surrounding tower installations as compared to in the same neighborhood that are not in direct proximity to the tower. Also, he's had numerous conversations with property owners, developers, and realtors who bought property around towers to see if there were any impacts. And then he also consults or has consulted with property appraisers the county property appraisers in various counties to say, do you take into consideration proximity to towers when you do values on the property? And as you'll see in the report, they do not, including Hillsborough County. So I will submit that in with at the end of my presentation. And then finally, on the variance question, essentially, if I'm going to go back to the, sorry. This is a picture of our 100 by 100 foot lease area. And you'll see here is the towers here, and here's where, the equipment will go up on platforms. And as additional co-locations are added, the platform would be expanded to cover those. And so the variance from the buffer is the type A buffer would require a 10-foot, I think away from the tower compound on the north and west sides. And so we have it pushed up into the northwest corner, not having that 10 feet because one, it's on this 26 plus acre church property. The church is the applicant. They are fine with it there. There's a ton of vacant property out surrounding it to more than meet that. And also based on, because again, this is in a retention area, this is kind of up in the northwest corner of the retention area and is the best location for it. And it also benefits the closest property to the south actually by being 10 feet farther away from the property to the south and also to the east. So in conclusion, we would ask for support on the special use permit and the variance. I think we've met all the requirements for it. We would ask for time. I know we have time to come back to address any comments from the neighbors. But we appreciate your time.
All right. Thank you very much. All right, we'll go to development services then.
Good afternoon, Development Services. Israel Monsanto. I think the applicant did a very thorough explanation of the request. So I will just touch in a couple of points to make it quick. So the antenna support tower for this proposed facility will be 164 feet on an agricultural single-family conventional one zoning property. The property is identified by folio 66-843-0200 and is currently occupied by a church. Pursuant to Section 61129D3 of the Land Development Code, a new wireless communication support structure located on agriculturally zoned property, in this case ASC 1, must be camouflaged, and per the code, compatible camouflage types for ASC 1 zone properties are bell towers, clocks towers, and tree-type towers. The subject site will be placed on the southeast portion of the church site, and according to the narrative, the church is leasing 100 by 100 vacant portion of the property to the applicant. The proposed location of the communication tower on the property is within the retention area and will be installed on a platform as noted by the applicant. The communication facility antenna towers are required to meet setback requirements of the host parcel zoning, except that when proposed adjacent to residentially developed or zoned properties, in which case a minimum setback of 100% of the tower height is required. This facility will be located 451 feet from the north, 518 feet from the east, 288 feet from the south, and more than 1,000 feet from the west boundary adjacent to Kingsway Road. These all setbacks comply with all the requirements. The proposed tower will be 288 feet from the closest property line developed with residential uses, both to the south and east. In regards to the variance, the applicant is requesting it from the buffering requirement from the Land Development Code Section 60606. The code requires 10-foot buffer with the type A screening between the use and the church property. The applicant's request to eliminate the required 10-foot wide buffer surrounding the tower compound on the platform. A type A screening in the form of a 6-foot high PVC fence will be provided on all sides. The applicant has provided the required variance criteria responses in this application. According to the application, because of the proposed tower locations within the retention area and installed on the platform, the tower compound will be unable to meet Type A buffering requirements, especially on the north and west. Given the site configuration of the lease area, the site would provide the required buffers along the south and the east of the compound with the solid fence, which will still be in place, screening the proposed compound, including for the future carrier expansions. The hearing officer today will be required to make a separate decision within 15 working days on the buffer variance in conjunction with this subject special use application. The applicant has submitted documentation indicating the need for the facility at a height of 164 feet of the desired coverage area and capacity needs, and that no other existing facilities are available for co-location to achieve their target level of reliable service coverage. Pursuant to the code, an outside expert has reviewed the support material submitted by the applicant. In that report, the consultant indicated that there is one existing tower that is approximately half a mile from the proposed location that could potentially improve the communication system coverage for the carrier in this area. Additional information was provided by the applicant to this consultant, showing coverage from both the proposed new tower and the existing tower. And based on the maps and additional information provided by Verizon, the consultant concluded that the proposed new tower location will provide an increase in reliable coverage, while utilization of the existing tower will provide just a slightly increase in the reliable coverage. So based on this analysis, the staff finds that the code, section 61129E3, the applicant has demonstrated that existing or approved wireless facilities are not located so as to allow the new proposed facility to function effectively and reasonably in parity with other similar equipment in place or approved. The applicant has also met other requirements of the code, has sent a letter of intent committing to antenna tower to share use of for co-location. No objections have been received by staff from other reviewing agencies. EPC, the Wetland Division's staff indicated no objections, no conditions are proposed, no transportation comments were received, and staff from the Aviation Authority zoning received the application and found it compatible with conditions. Based on all these findings and based on the request, the staff finds this request approvable with the proposed conditions noted in our staff report. We are available if you have any questions.
Thank you, Mr. Monsanto. All right, Planning Commission.
Hi, good afternoon, Madam Hearing Officer. Before I give my testimony, I just wanted to make a correction for the record because we noticed an oversight on our staff report. The second to last paragraph in our staff report has some language that mentions incompatible or inconsistent development when that is not in fact accurate for our finding, as it notes in the last paragraph that states that we are finding it consistent. So I just wanted to note that for the record before I begin my testimony, if that's okay.
Thank you.
The subject property is in the residential 6 future land use category. It's in the urban service area and located within the limits of the Brandon Community Plan. Typical allowable uses within this designation include low density residential, suburban scale neighborhood commercial, office uses, multi-purpose projects, and mixed use development. Non-residential uses shall meet established locational criteria for the specific land use. The residential 6 designation surrounds the subject site on all sides. The residential 4 designation is located further east across Sefner-Valrico Road. The public/quasi-public designation is located to the southwest of the site. The subject site is surrounded by single-family residential dwellings. A school is located to the southwest of the subject site, and light commercial uses are located closer to the intersection of Kingsway Road and Windhorst Road. The proposed special use is compatible with the development pattern of the surrounding area and meets the intent of policy 1.4 of the future land use element. If the applicant, as it will provide services to the surrounding area. The proposed special use is not encroaching onto residential uses that are located to the south and north, and there is significant distance between the tower and residential uses, thereby meeting the intent of the neighborhood protection policies of Objective 16 and policies 16.1, 16.2, and 16.3. The proposed special use meets the intent of Objective 46 and policies 46.1 and 46.2 that require telecommunication towers and facilities to locate in areas with compatible land uses and adhere to all local, state, and federal laws. The location of the tower is considered compatible with the existing uses on site. The applicant is requesting a waiver to the Type B screening and buffering requirements due to the tower being in a retention area and being raised on a steel platform. The applicant is therefore proposing to screen the tower with the 6-foot opaque vinyl fence. The proposed special use meets the intent of Goal 3 of the Brandon Community Plan by providing updated wireless infrastructure to the surrounding community. Overall, the proposed special use would allow for a development that is consistent with the goals, objectives, and policies of the Future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County, and that is compatible with the existing and planned development pattern found in the surrounding area. And based on those considerations, Planning Commission staff finds that the proposed special use is consistent with the comprehensive plan, subject to the conditions proposed by the Development Services Department. And that concludes my report. Thank you.
All right, thank you. So we'll go to public comment. Is there anyone here or online who wishes to speak in support of this application? All right, don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? Please come forward.
Good afternoon. My name's Judy Valeri. I live at 955 Sandywood Drive, Brandon, Florida. I've been here since this morning. I feel completely discouraged at this point. I've been sent here by my neighborhood. People are concerned. But apparently, we the people don't count that much. This is a map of the area. As you can see, it's densely surrounded by homes, over 400 of them. So I've heard people say this afternoon that there's really no problem with them. The radiation isn't a problem with them. The property value isn't a problem with them. The American Academy of Pediatrics says that kids shouldn't live within 400 yards of these towers because of the radiation that comes off of them. There have been different articles that have been written that show that property values decrease by up to 20%. Fact, fiction? I talked to a local realtor who told me, yes, indeed, our property values dump as soon as the tower goes up. And not to worry, because we will still be able to sell our homes because people will buy something at the lowest price possible, no matter what kind of a health hazard they're put near. It's been shown from these towers that women have a much greater chance of miscarriage. It's also been shown that some fetuses have fetal development problems. I was sent here from my neighborhood to say that, we're just not in favor of this. Some of the radiation from the umbrella can cause interference with cell phones. Not a good thing if you're on a cell phone trying to call 911. So we're not for it. But I know at this point that's not going to do a darn bit of good. But at least I've made my voice known. And I'll turn these petitions in with the other signatures of my neighborhood so that you have them. Thank you.
Thank you. Is there anyone else here? Okay, if you wish to speak in opposition to this application, please come forward.
My name is Lauren Law. I live at 615 Schultz Drive, Brandon, Florida. I represent the residents of the Mayfield subdivision adjacent to the property now owned by Bay Life Church, where I have resided for 33 years. We stand in opposition. You must not let this go forward. It has been well documented with scientific data that cell towers have detrimental effects on the surrounding population due to radiation, electromagnetic frequency emissions, and noise from cooling fans. Effects on children and adolescents are headache intensity, nightmares, dizziness, sleep disorders, delayed spatial working memory, fine and gross motor skills, attention, concentration, lower verbal expression, comprehension, internalizing, type 2 diabetes, obsessive compulsive, post-traumatic stress, inhibitory control, and cognitive flexibility. Effects on adults, cancers, DNA damage, neurological disorders, hardening of the arteries, diabetes, liver cirrhosis, asthma, hypertension, reduced blood flow, headache, fatigue, ocular dysfunction, blood changes, dizziness, sleep disorders, reproductive and cardiovascular abnormalities, depression, irritability, memory impairment, and dermographism. Pets and surrounding wildlife are even more sensitive. They can hear and feel frequencies we cannot. Many birds and insects, such as bees, use the Earth's magnetic fields to navigate. REFs gravely interfere with that navigation. There are already at least 18 cell towers in the surrounding area. We will never be able to sell or rent our homes because no one in their right mind is going to want to live there, nor should they. And to the church, I say shame on you for valuing money more than your community. I would like to submit these documents and petition for the record and consideration. And as far as the appraised value of our homes, that means nothing if no one is going to want to live there. And if they're building the cell tower in the retention pond, are they going to build a new retention pond? That area has deemed ecologically sensitive by the EPA. When the church first bought that property, and I knew the people who owned the property before them, when the church first bought that property, the EPA came in and told them that they were not allowed to build any further structures because it was detrimental to the immense amount of wildlife that is in that small pocket surrounded by subdivisions. There's an incredible variety of wildlife living there. So if they're building in the retention pond.
Okay, ma'am,
Yes,
there's just a little over 8 minutes left. Are there several other people who wish to speak? And I don't want to cut you off.
no, you are
If you're-
correct.
Okay. I just want to make sure everyone who is here who wishes to speak has time.
She can finish.
Are you finished, ma'am?
So they were told they could not build anything. If they're going to build in the retention pond, does that mean they have to dig a new retention pond, usurping even more wildlife than they have already? I have seen with my own eyes how they have killed gopher turtles because I live directly adjacent to them. They've killed gopher turtles. They have poisoned the raccoons. I have seen them shoot animals in their burrows. These are not people of God. It's horrible what they're doing. And I've seen it with my own eyes. I tried to get someone from the EPA to come down when I saw them killing the gopher turtles. And they gave us a different agency who eventually came in after it was too late, saw the evidence for themselves, but it was too late for them to do anything about it. This is not right. They care nothing about the population. Yes, the FCC cares not about our health, but they did give us a buffer zone, as small as it is, which is way too small. They did give us that buffer zone. Do not allow these people to waive it. Please, I beg you. Thank you.
Thank you. Right, how many more people, are you the last one, sir?
I believe so.
Okay, please come forward. Thank you. And make sure the microphone is up. There you go.
Good afternoon, Madam Hearing Officer. My name is Milo Milovich. I live at 949 Wicket Run Drive in Brandon, Florida, 33510. I am a resident and the current HOA president of the Dominion Homeowners Association. And we had previously submitted a petition of disagreement that was faxed prior to this meeting, signed by 65 individuals who are against this. Our belief is that the installation of a cell phone tower is going to be detrimental to because of the high energy, high frequency electromagnetic radiation, health hazards. We believe that our property values will be decreased. I've listened to the testimony by the petitioner who wants this. The studies that have been done as far as property values, health issues, and all that. I worked in the federal government for 24 years, and I know how studies are sometimes conducted. Statistics can be skewed in any direction you want them to go. Bay Life Church has been a poor neighbor. When I bought my house 16 years ago, I made the stupid mistake of not looking to see what was on the backside of my fence. Because of that, if I had known Bay Life Church was actually my neighbor, I would not have bought my house because they have been a poor neighbor over the years. This is just another incident of that type of nature that they're selling out for profit. They're leasing their land for profit for a cell phone tower. I have Verizon telephone coverage with my cell phone. I have no issues in that area. So on behalf of the residents of the Dominion Homeowners Association, we are against this. And that is all I have to say. Thank you.
Okay, sir, thank you. All right, is there anyone else here or online who wishes to speak in opposition to this application? Okay, going back then to development services.
No further comments unless you have a question.
Okay. No questions for development services applicant?
I'll be brief because I know it's been a long day already. I think it's important to note one of the neighbors, and we appreciate their comments, but one of them said this is surrounded, by a dense area of homes. It's the homes. It's the exact reason why the tower is needed. We've located it on the best location that will then serve as property owners. And I just really want to show you, again, this is the retention area where it's going to go. It's going to go up in this corner. And just to get a better perspective on how much area there is out there and where this is going, that's looking at, I think that's looking to the east, and that's where the tower is going to go approximately. And just finally, here's a look back at the property to the south. The tower is going more over here, but as you can see, there's a dense tree canopy all along the southern border, along with, you can kind of see it, well, it's hard to see, but there is opaque fencing as well.
Mr. Johnson, since we're on the topic of where the tower is going to go in the retention pond, there was a neighbor brought up an issue of whether a new retention pond would need to be built. Can you just address that question? Will the retention pond have to be altered at all?
No, it will not. This has very minimal impact. Again, the equipment's going to be on a raised platform. The only thing that will be in the ground really is the base of the tower. So this will not impact that.
All right, thank you.
And then just really quickly, I know there was, they all talked about the health. And again, as we've mentioned, it's not an issue for a zoning hearing, but again, we will meet all FCC requirements for the permitting or for the permitted antennas. There were a lot of disparaging comments about the church, which I don't think really have a place here in the zoning hearing. Property values was the final thing. And again, I think the only competent substantial evidence really that's been offered is the document from our appraiser on that. So again, we appreciate your time and we'd ask that you recommend or approve this special use permit and variance.
I guess just one more really quick question. EPC didn't have any comments about wetlands, this impacting wetlands. Is that correct?
Correct.
Okay. All right.
I mean, again, it's in an existing stormwater pond.
Exactly.
Thank you.
All right. Thank you, sir. So that will close the hearing then on special use 22-0826.
That brings us to our final case on the agenda today. This is in section I, appeals. And case is I-1, appeal number 22-1146. This appeal is of the administrator's determination in NCU 22-076 2 concerning the number of spaces permitted in a non-conforming recreational vehicle park.
All right. And is the applicant coming forward? Okay. So this is an appeal. The process is going to be a little bit different. We're going to hear from the appellant first, and then we'll hear from the county, and then the appellant will have time for rebuttal. And my decision in this case, because it's an appeal, is due in 5 business days. So I will have a decision submitted within 5 business days of today's hearing. Okay, so we'll hear from the appellant, please. Just list your name and address for the record. Thank you.
My name is Linda Stevens. Address is 1709 50th Street South, Tampa 33619. I'm 81 years old, so this brain doesn't work that well these days. So I'd like to ask that my daughter help me with this. But the appeal is when they made the last when I made the last appeal, yes, he gave me the use of my mobile home RV park that had been there for 75 years. Well, he took away 4 of the spaces. And this is what I'm appealing, is the use of these other 4 spaces is very necessary because people are begging me for spaces to put their RVs because they cannot afford the high rents today. And so they're turning to RVs to live in full time. My park is a nice, clean park. I'd like for my daughter to show the pictures that I have because my park is an asset to the community in every way. Everything I have up and down 50th Street now, due to the zoning that was changed a few years ago, are junkyards, used car lots, junkyards for trucks, storage for racks. Everything has deteriorated the whole area there. My park is the one thing that has nice places. I don't have drugs. It's a nice, quiet spot. But also, I had been given permission. I'm out of breath.
Take your time.
I had been given permission by the health department to have these 12 RV spaces because I deleted the 8 mobile homes that I had originally been given permission to have in there. Those mobile homes required 2,600 square feet each. RVs require 1,200 square feet each. And so I have plenty of space, as these pictures will show you, for a nice park. My trailers are spaced. Can you talk? I'm out of breath. Thank you.
Apologies. So as Mom was pointing out from the previous,
You just state your name and address. Thank you.
Angie Villarosa, 4445 Hidden Shadow Drive, Tampa, Florida, 33614. All right, so I guess to start back from where Mom left off, the last time we went through the review, the spaces were changed from the original spaces that we've had since the Florida Department of Health provided.
And I just want to ask you to clarify something. You said since the last time you went through review, what review are you referring to?
The original non-conforming use that was handed down in June, I believe, was
the review that you're appealing.
Correct.
Okay.
Correct. Thank you. All right. So from the license here, you can see that this is where in 2005, the Florida Department of Health provided the change from the 8 to the 12 spaces. And again, just to elaborate, that was because of the square footage that was previously allowed in the park with the operating permit being here dated April 1975. All of this data should have been provided in the appeal. But we have copies here we can leave behind as well. Again, the footprint of the park has not changed, only the footprint of the spaces, which thereby allowed her to be able to move from mobile homes to RV spaces. So,
do you know when did it occur that this park changed from mobile homes to RVs? And you can pull, Ms. Stevens, you can pull that microphone down. And you need to turn it on too. Just one moment. Let's get you on the microphone. Yes, ma'am.
In 1965, I applied for RVs instead of mobile homes. And so they granted me that according to this document I have right here. He granted me, instead of the 8 mobile homes, 12 RV spaces.
Okay, let's back up one second. You said 1965. Is that accurate?
2005 was this license here.
Okay, yeah, let's get that straight. Was it 2005?
2005.
Thank you. All right. So 2005, your park changed from mobile homes to RVs. Is that correct?
Right.
And is that when it changed from 8 units to 12 units?
Right.
Okay, and that was 2005.
Right.
Okay. All righty. Thank you for that. Go ahead, please.
But I've had an operating permit. It was before, when I purchased the park in 2000, the people already had, the Pettits already had an operating permit there to operate since 1975.
Where was the operating permit from? What do you mean by an operating permit? Who issues that?
The
State of Florida Department of Health.
Yeah.
That's the Department of Health? Okay. So the Department of Health had issued an operating permit since 1975, and that allowed for 8 mobile homes.
Right.
Correct? And then in 2005, you changed it to RVs, and it was 12 units.
Right.
Okay. All right.
So again, what she is appealing and asking is, based on the previous decision, we would like to request that the additional 4 spaces are returned back to us based on our licensing permit. Obviously, it impacts her from a revenue perspective. She can't charge a lot rent. And for the travel trailer that is in place, she cannot make any money off of rental folks coming in. She actually has quite a few gentlemen that come in on a regular basis that work at Tampa Electric as consultants. And so they're here for maybe a few days, upwards of a few weeks, sometimes for a few months. So again, they've been coming for about a decade now. And so even while she's sitting here today, she's getting text messages, hey, Miss Linda, do you have a spot that we can use? So again, it's being impacted from a revenue perspective, as well as I believe that that she's just done her due diligence with making sure she was licensed correctly for the 12 spaces.
Yeah, since I purchased the park in 2000, I've been purchasing permits from Hillsborough County to operate Pettit Mobile Home RV Park since 2000.
For how many units?
At that time, I actually had I still only had one mobile home at that time, and the rest of the time I had not 12, but I had several RVs in there. And so, what I wanted to show here is the front of my park, that the front of my park is very nice. My park is well maintained. I don't have drugs. I have a peaceful park there for people. And you can see this one shows I have plenty of space between the trailers, so they're not jammed together. But here's what I have to look at. That's next door to me. That's across the street from me. That's at the end of my street. This is what's in my neighborhood now. So my trailer park is an asset to the neighborhood. It adds to it. It doesn't detract from the value. I've lived there since my parents moved there in 1949, behind this park.
I see. Do you live at the park?
No,
No. Okay.
I live just down the street.
I see.
But I'm requesting, please, to have these 4 spaces that helps me pay the property tax that are always increasing. And I'm 81, as I said, and I'm still trying to maintain these premises to have a nice place and provide something for people to stay.
All right. Thank you. Is that all for now?
Yes, ma'am.
Okay. We're going to hear from the county, and then I'm going to have you step back up for any additional information you want to provide, okay?
Okay.
So you might stay down front. Thank you. They need to sign in with you, right? They need to sign in with the clerk, right? Y'all need to sign in with the clerk also, please. Do you want to go ahead?
So the subject property is zone CG, general commercial, and that zoning does not permit a mobile home or an RV park. This zoning was put in place in 1991 during the zoning conformance process. Prior to 1991, the property was zoned C2 from 1968 till 1991. Evidence was submitted by the applicant and during the review of this non-conforming use review to show that by 1975, at least, that there was a mobile home or a trailer park, was deemed a trailer park at that time under the code, was in operation and submitted an HRS operating permit for 8 spaces. In 1980, the zoning code changed and trailer park was no longer a permitted use of the C2 zoning. So in 1980, the park became a non-conforming use. The determination that we made was that a mobile home / RV park is a legal non-conforming use of the site, but with a maximum of 8 spaces. And the basis of that is that there was no evidence submitted by the applicant in the way of operating permits, things like that, which showed that more than 8 spaces had been permitted prior to 1980. And in fact, in her statement today, it appears the applicant has stated that the number of spaces in this park was changed from 8 to 12 in 2005. But because the fact that 1980 this no longer was a permitted use of the property, but became a non-conforming use, any kind of expansion of the permit of the park that took place after 1980 in the terms of the number of spaces, land area, things like that. And this is true of all non-conforming uses, not just this case. With those, anything above the level that was there in 1980 when the park was no longer permitted use of the zoning under the amendment to the zoning code in effect, cannot be certified as a legal non-conforming use. And that's the basis of why it was limited to 8 spaces. And let me add that even though there were permits that were submitted from like operating permits, things like that from various agencies after 1980, and I believe well after 1980, while those kind of permits are valuable to establish that something was on a site, those permits do not obviate zoning regulations in themselves. So.
All right. Don't think I have any questions for you right now, Mr. Hisney. Thank you. Would the applicant like to come forward? Do you have anything further? All right, make sure you get to the microphone first, please.
8 independent mobile homes.
Yeah, this is the permit that was given in 1975, is that right?
Correct.
In 1975, the operating permit to the Pettit, it allowed 8 mobile homes in 1975. And so I changed from that because I didn't want big mobile homes in there. I just put in smaller RVs because that's what everyone was really requesting. And there's other mobile home parks around. People are needing desperately spaces to park their travel trailers. My son just sold his house and bought a travel trailer, and he had to go way out past Riverview, way down one of those roads out there to find a place to park. All the area of the decent parks are booked for 2 years.
Okay, let's go back to the, you said you had the operating permit for the mobile home. That's 1975. But it became 12 units, 12 RVs.
In 2005.
In 2005.
Correct.
So.
RVs and 1 mobile home. So.
Okay. All right. Anything further?
No, ma'am.
Okay.
But it would be a hardship on me as if you don't let me allow those 4 places because I need the money. $25,000 property tax I had to pay last year. At 81 years of age, I'm still having to worry about my property.
Okay.
Can we leave copies with
Yes,
someone?
please. You can leave these, anything you want to submit to the record, you can leave this with the clerk today.
Thank you for listening.
Yes, ma'am. Thank you. And so applicant's going to submit those items, and this will close the hearing on the appeal 22-1146. And that will conclude our land use hearing officer meeting today.